On May 29, 2024, court's march operated by our court clerk, Sue Hall. Our official court reporter is present. She is the official record. The court smart recording is not available for release. This is State versus Christopher Gregor, case 21-1881. Would counsel please put their appearance on the record?
Your Honor, Christine Lento appearing on behalf of the state.
Assistant Prosecutor Jamie Schroen for the state.
Good morning, Ms. Lento. Good morning, Ms. Schroen. Good morning, Your Honor. Mario, Ms. Ferrante. Mario Bellucci on behalf of Mr. Gregor, who is seated to my left.
Thank you. Good morning, everyone. Mr. Gregor again appears appropriately attired in a gray suit and tie. I have not heard from jury management yet about all the jurors being present. I understand there's some challenging issues with parking today. Yesterday we discussed certain exhibits that the defense wanted to move in, and that was D4, D5, and D8. Is there an agreement amongst counsel as to that?
Yes, Judge.
Yes, Your Honor, there is.
And that,
there is no D5, but it would be D4.
And D4 was amended, I think, from what was actually used during the trial. It's a 3-page document now, and those 3 pages should be put in their entirety.
all right, so D5 is ID only. D4 is admitted by consent, but limited to 3 pages by agreement. Is that right?
Yes, Judge.
All right, so D4 in evidence as amended and by consent. And then what about D8, the release signed by Ms. Micciolo?
Judge, we're not putting that in.
We're not putting that in?
We're not.
Okay, so that is ID only. And then, Ms. Schroen, before we open, you wanted to confirm about S-125?
I confirmed with Ms. Hall about the S-125 and 126 were ID only, not in evidence. I just didn't want to put them in the evidence pile that goes back.
So then after your closings and the jury charge, if both of you could go over the evidence jointly to make sure whatever in the box is appropriate evidence to go back to the jurors. And then defense is not using a PowerPoint, but the state had an opportunity to view the exhibits that the defense may place on the TV screens, correct?
Yes, Your Honor.
All right.
That's correct, Your Honor.
And you have a copy of the PowerPoint for after the defense is done to review the state's?
We printed one out, we do. Thank you.
Very good, thank you. All right, so we have, just to amplify on the record, at the request of counsel, a second flat screen TV. This one positioned essentially at the opening of the jury box where the jurors would enter, closest to seat number 1 and seat number 9. It displays simultaneously with the images that are on the large screen TV, which is permanently mounted on a wall. Do we want to turn that flat now again, or it doesn't need to be tilted towards me? Ms. Grimaldi, can I ask you to? I think we just did that before because they were putting some wires behind it. You can even turn it towards the audience if you want.
Yeah, I was looking at it. You'll be able to get push things away so that you're not going to be obstructed. And the judge said even if you're standing, nobody's obstructed or anything. It doesn't matter. And they can still see that one if they want to. That one. It's actually hopefully it's even more natural than this arrangement.
We could send somebody, Ms. Grimaldi, and an officer. I'm going to give them a couple minutes to get settled in the jury room when they get here.
Okay. Yeah.
Madam Clerk, that went in yesterday? It did not. All right, so that's agreed to, D13?
Yes.
All right, so D13 in evidence.
Received. They're on their way, Your Honor.
Thank you. Good morning. I'm going to go to the jury room and get settled.
Okay.
All right, 1021, jury in the jury room. Let them get settled for a minute. 1024, jury out.
All rise.
Thank you. Please be seated, everyone. Good morning, ladies and gentlemen. Understand parking was a little challenging today, so I hope that worked out for you. Any issues or concerns you need to bring to my attention? All right, great. Seeing none, the order today is the summations first by defense counsel and then by the prosecution. We'll obviously probably take a break between the two of those, and then depending on where we are in the morning or lunchtime, and at some point we'll get to my jury instructions to you, my final charge to you. We have a second TV set up. As you can see, they're going to be simultaneously playing the same thing. If you have any difficulty seeing or hearing anything, just please tell us right away and we'll stop it or start again or adjust it however we have to. Anything from counsel before we begin?
No, Your Honor.
All right, Mr. Gallucci.
On April 2nd, 2021, the world lost a shining light named Corey Micciolo, a 6, almost 7-year-old boy who died. That is tragic. No child, no matter what age, should die. But he didn't do it. He did not kill Corey. And they did not bring in one police witness, one doctor, one expert, one single layperson that showed you any evidence that Christopher caused an injury to Corey that killed him. Oh, they brought in cell phone records, they brought in text messages, they brought in phone calls, they brought in internet searches, they even brought in police from Alcoa, Tennessee. Ms. Lento yesterday sat here and cross-examined Dr. Bonnet. Her cross-examination consisted of, did you review this text message? Did you review this phone call? Did you review this record? Did you review this record? Her cross had very little to do with medicine. She touched on it, but most of it had to do with, did you know that he had a school teacher that reported seeing a bruise? And the doctor agreed with her. As a matter of fact, at one point, Dr. Bonin said to her, I'm agreeing with you too much. But he also testified that none of that stuff had absolutely anything to do with Corey's death. Nothing to do with Corey's death. The one person that might have been able to come here and explain to you Corey's death would be perhaps Dr. Ragassa. Dr. Ragassa was the medical examiner. Dr. Ragassa is the one that dissected Corey. Dr. Ragassa is the one that prepared the slides. Dr. Ragassa is the one that took each and every organ out of that body. Dr. Ragassa is the person that ordered the exams he thought were appropriate, such as a lung culture, not a blood culture. Dr. Larkin who worked for the ME's office. There was another person. Took a CAT scan. Now, did we hear from the medical examiner? Did we hear from the one person who did all of these tests, who ordered all of these tests? No. His report, every single expert, forget about Dr. Bonnet. Forget about Dr. Bonnet. Dr. Andrew relied on their medical examiner. Dr. Feingold relied on their medical examiner. And yes, Dr. Bonnet relied on their medical examiner. Relied on those slides and relied on that report. We heard Dr. Ragazza's name mentioned more in this case than we heard Christopher's name mentioned in this case. He was the one that did the autopsy. The person that did all of the work here. And we didn't hear from him. And I'll show you why. I'll show you why. I'll show you that there was a concerted effort to show you bits and pieces of things. Let's show a little bit of this. Let's show a little bit of that. At one point they introduced a text exchange. Part of it. I got up and I introduced the whole text exchange. So you don't get to pick and choose little snippets of what you want you to say. You deserve the whole story. What else did they give us? They gave us a doctor. Dr. Deacon sat here in this chair. 10 minutes before you walked in here, we did a hearing with Dr. Deacon. She testified one way. We brought you into the courtroom. She testified another way. They gave you a nurse, Lindsay Carnivale. Okay, I'm going to get to Lindsay. Lindsay Carnivale. She's a member of Justice for Corey. She's the one that said that Christopher was under emoting. By the way, that's a word I never, ever heard of in my life till I stepped in this courtroom. Under emoting means that he wasn't emotional enough to her liking. Member of Justice for Corey. We all want justice for Corey. We all want justice for everybody. Justice is not convicting a man for murder who did not commit a murder. That's not justice. Justice is an honest and complete look at the evidence. Justice is you using your common sense. You were chosen out of hundreds of people to sit here and deliver justice. That's why you were chosen. One of the only things we agree on is we believe that you were the perfect people because you would listen to the evidence, you would listen to the judge's charge on the evidence, you will go back in that room and you will apply that to the evidence. Good morning. I'm Mario, and I have the honor of representing Christopher. And this is my summation. And this is it. You don't get to hear from me again. Some of you may be very happy about that. Some of you maybe look forward to coming here every day and watching me prance around the courtroom. But this is it. This is the last time I get to speak to you, and I'm going to talk about what we know. What we know. What did the evidence show us? So where should we start? Let's start at the beginning. Beginning of this case, we find out that Dave Gregor, Christopher's father, receives a phone call from somebody. He introduces herself as Rebecca Micciolo, and she's looking for some type of support for a child that Dave Gregor had never met. And this was back 2018. Child was 5 years old. We know that Christopher takes a paternity test. And guess what? He's the father of a 5-year-old child that he never met. So, what does Christopher do? Quits his job working for Urban Teachers down in Baltimore, Maryland. Moves back to Monroe, New Jersey, and moves back into Mommy and Daddy's house. And what do they do at that point? They have a plan. They meet, as families do. What are we going to do? We now have a 5-year-old child of Christopher's. So they decide as a family how they're going to go forward. They meet young Corey for the first time in August of 2018. At that time, he's 5 years old. 5 years old. They bring him into their home. I believe Dave Gregor testified that he went through the house to find the objects that his 4 children used when they were growing up in the house, and they tried to make it comfortable for this young man. We know if that was in August, come October, September, October, and if we throw in August, 3 months later, this 5-year-old boy who's been with presumably his grandmother, Rebecca, they now get parental custody of this child. Within 3 months, the Gregors now become the residential parent of a 5-year-old child they have never met until 3 months earlier. And that speaks volumes. Volumes on how the Gregor family, within 3 months, become a residential parent of a child that they just met who is 5 years old. And what do? They embrace it. They embraced it. You heard Dave Gregor testify that they enrolled him in the schools in Monroe. Christopher was working down South Jersey. He would leave early in the morning. Dave would get him on the school bus. Dave was retired from the state troopers. He would get him off the bus. Christopher would come home. They would do homework together. Dad would play soccer and basketball and baseball. He told us all those activities they did to bring this young man into their home. They set up a room. He had his own bedroom. Grandpa became like a dad. Dad was working, and he would come home. And they moved all merrily along as a nice, happy family until January of 2020. And what happens in January of 2020? Brianna loses custody and visitation. Why? She has a drug issue. Which is, people have drug issues. People could rehab from drug issues. But she has a drug issue. And now they went from having no child to now being the sole parent in charge of this young man within about 5 or 6 months. This arrangement continues until Brianna finally, she testified. I'll get to her. Believe me, I'm going to get to her. But so she finally cleans up her act and begins to get some visitation with her son. Her son, that her mother during this time had visitation with. But she did not have visitation with him. She gets 1 day a week and every other weekend. We know Christopher moves out of the house. He moves to Barnegat in August of 2020, I believe. And at this point, everything is hunky-dory. Everybody is fine. She's got her visitation. As a matter of fact, at some point, there was testimony that the two of them were basically living together. She testified that they were looking at homes together. And then what happens? Something happens. Because that relationship now becomes acrimonious. And as I was sitting there last night and over the weekend thinking about this, I'm like, what happened there? What happened that everybody was on this beautiful path, and then all of a sudden, everything went downhill? And I remembered the conversation that the state put in with Mr. Cicero. The conversation where he called D.C. P&P. And during that conversation, he said some things. And in those things, he said that I'm concerned that the baby's mother, Brianna, is relapsing. I'm concerned that she has entered back into a relationship with her ex-boyfriend. And this is now, when we go forward, is corroborated actually by Brianna and her testimony. That, and I'm going to get to it, but she reaches out to Justin for a bump, if you remember, a bump. Can I get a bump? I'll get to it. But that's where we start seeing now this relationship, maybe this is going to work. Maybe these two kids are going to live together and going to raise this kid, Corey, together, and everything will be fine. Well, that's the furthest thing from the truth. And we know what happens. So now, on March 19th, not her regularly scheduled visit, she asks permission. Can I have Corey? Because remember, she only has visitation rights. So it's once a week, every other weekend, she wants to see him. And what does Chris say? Sure. Go ahead. Take him. But I want you to bring him home at whatever time. He allows it to happen. And what happens? She doesn't return. She says she hit traffic. They argue. She arrives late. And she ends up meeting Christopher at the gym. And we see this chat going on between the two of them. This acrimonious chat between, where are you? I'm going to take away some of your parenting time. Tit for tat, the two of them, back and forth. Drop them off. And she does. She drops them off at the gym. and we see Christopher go to her car, and you see them have a discussion. We can't hear the discussion, but you could see that that discussion was not a happy discussion. And what do we see next? We see Corey going to the gym with his dad. We see his dad pointing to a treadmill. We see that young boy get up on the treadmill all by himself. We see that young boy operate that treadmill all by himself. This is not the first time that child was on a treadmill. That child knew exactly how to work a treadmill and knew exactly what to do. And then we see what we saw. I didn't like it. I didn't like it. I'm sure you didn't like it. I don't really care if you liked it or not. And I don't care if you liked him or not. Because it doesn't really matter. Because every single expert said, even their experts said, that treadmill had absolutely nothing to do with his death 12 days later. And I'm not conceding, by the way, endangering. I don't want you to think for a minute, oh, Mr. Gallucci's up there saying, oh, he's guilty of endangering. Absolutely not. It's not the way I would run a child on a treadmill, but I don't have a relationship that he had with his son. I could tell you what I saw in that video. I could tell you that when it was finished, I saw Corey get off that treadmill. I saw Corey run out of a gym. I saw Corey walk out. Everybody makes a big deal about the fight. And I gotta tell you, when I first saw that video, and I saw him grab his head, I was like, so, name one single doctor, Deacon, the doctors from Community Health, Dr. Auld, Dr. Andrews, Dr. Feingold, even Dr. Bottom. Name one doctor that said there was any evidence of a bite mark to the top of Corey's head. Not one. We have 2 body charts. They went to great lengths with 2 body charts from 2 different doctors. Did any one of those doctors indicate that was a bite on the head? There was a bite mark on the head. No, not one. So what was it to me when I go back and I look? I see a frustrated father. I see a father who's frustrated. By the way, Corey kept getting back up on that treadmill. There's only one time he puts him on the treadmill. Corey keeps getting back up on that treadmill. And the point he tries to put him up on the treadmill, he's trying to get his feet on the side, not from where it's running. And you see him go down on his head. To me, after looking at it again, and after reviewing the evidence, and after looking at the medical records, and seeing that not one single doctor said that was a bite, that was a frustrated father. Ah! I don't know how you transcribe that, but that's what that was. No physical evidence. And how else do we know that Corey was okay after that treadmill? 2 days later, He's with Grandpa and Grandma. He's down in Barnegat, looking at houses. Dave Gregor testified that they saw 2 homes. One home was close to the street, and they were concerned because Corey was running around. He was energetic. It's 6. What 6-year-old isn't energetic? A 6-year-old that just got really hurt badly on a treadmill is maybe not energetic. But not a 6-year-old that did not get hurt on a treadmill. 2 days later, he's energetic. He's fun. They go to a relative's house. They hang out. Corey's bored. He wants French fries. That's all he wants. What 6-year-old doesn't want French fries? Hell, I want French fries. All right? 6 years old, he wants French fries. They go out to dinner. They take him down to a restaurant that's on the bay, I guess. Corey eats French fries. And he's got a bruise to his head. That they see. And they discuss. He visits Brianna on the 23rd. 3 days later. She doesn't do anything. She doesn't call DCP&P that day. She doesn't alert anybody to the fact that my Corey is hurt. This is her visitation day, the 23rd. 3 days after treadmill. And I'm going to get to this. But, the bruises were different ages. I'll get there. 3 days later, she has him. Not an issue with bruising. Not a word. Not a call to DCP&P. Nothing. 3 days later. The 27th. 7 days later. This child is trying out for a football team. A football team. 7 days later, the boy that was supposedly abused on a treadmill, who's injured and hurt, is trying out for a football team. 7 days later. The 28th. Now she goes to DCP&P. I see a bruise. I see this. I see evidence of this. They call the police. And the police come. And by the way, I don't have to do a thing. I could have sat in that chair through this whole trial and did absolutely nothing. I told you I would, but I could do absolutely nothing. The burden lies right here with Ms. Schron and Ms. Lento. I called the police on my case to show you that 2 police officers responded to check out Corey. 2. Officer number 1 was Dugan. He actually looked at Corey, didn't find anything wrong with Corey, noticed some bruising, didn't think anything of it, had a discussion with this other officer, and actually testified that he believed that Christopher and Corey had a good relationship. This was an investigation for child abuse. 8 days after the treadmill video, 2 officers, not one, 2 officers go down and they meet Corey, they talk to Corey, they look at Corey, they speak to Christopher, and what do we get from that? We have a good relationship. Officer Roman, I believe his name is, he comes in too. And what does Officer Roman say? Officer Roman says that he has seen in the past Corey and Christopher up at the turf field playing football. He's seen them together playing football. And I believe it was Miss Lento. I may be wrong. Your memory is what's right here, not mine, not anybody's, but yours. I think it was Miss Lento that asked him what he was doing at the football field. And I believe he said he was throwing passes. As a matter of fact, I believe Officer Roman went so far as to say he was diving for passes in the end zone. Diving. That's what 6-year-olds do. They dive, they fall, they bump, they hit things. It was 8 days later. 8 days after treadmill. There's nothing wrong with Corey. Zero wrong with Corey. Every single time there's an issue, we roll out treadmill. Treadmill ad nauseam. And I'm sure, I can guarantee you, before you leave here today, we're going to see treadmill. Guarantee it. Guarantee it. Not one single person, not one lay person, not one doctor, not one police officer, not one expert has said anything about that treadmill causing an injury that killed Corey, or better yet, that caused any significant injury whatsoever to Corey. We have body grafts. Two doctors, Dr. Deacon, Dr. Ung, do body grafts. And I'm going to get to the information that we're given in a minute. But in the body grafts themselves, do they delineate on those body grafts the injuries that were caused from falling on a treadmill? We know they didn't see any bite marks to his head. Do they delineate, oh, this bruise must have happened from a treadmill, this bruise must have happened from a football fall, this bruise must have happened from OE6, although one of them, I think it was Deacon, and I'll get to her, Deacon did testify that, 6-year-olds fall. On April 1st, we're now 11 days after treadmill. 11 days. Brianna applies for an emergent court order. My son is being abused. It's 11 days later, by the way. She's had him through those days. But 11 days later, now today, why? Why? I thought about it. So why 11 days later, out of nowhere, does she just do this? Well, he does have bruises. He does have bruises. And what does that mean? Aha! Maybe I could get custody. Maybe I could have more than just visitation. Maybe the court now will give me my little boy. And I don't have to run from Jamesburg down to Barnegat once a week. Here's my shot to get my boy. And what happened with that court order? It was denied. Denied. Yet again, she got struck down another time. But in the court order it says both parents mother and father should schedule a visit with the pediatrician together. And alas, here's my opportunity. So when she gets that, she sees that language, what does she do? She runs him immediately down to a pediatrician. She actually testified about this. Not in so many words, but she testified that she was trying to get full parental custody back, and that she was working on cleaning herself up. And here's her shot to do it. So she violates the court order, and that's important. Not because she violated a court order. We should always obey a court order. I'm not saying that you should go out and violate court orders, but it's important to this case that she violated a court order. She was assigned a DCP&P worker. I think his name was Mark Walnowski from DCP&P. By the way, I don't think we heard from him either. Yet another person that we hear throughout the whole case. We hear DCP&P, we hear about a worker, but none of them came here to testify, to tell you anything. Bits and pieces. So at IV Pediatrics, what do we get? We get a pediatrician, Dr. Plesher, Dr. Deacon. She's the one that we did a hearing. And at the hearing, she testified about how she was speaking to Corey and how she got information out of him. And then after that, you all came in. It's like a dress rehearsal, I was calling them. You all come in, and she completely changes the testimony as to what she did with Corey. And I got angry with her. And I'm sorry, I yelled at her. I wear that. I yelled at her. I lost my cool. Because she lied. She completely changed testimony from a hearing 10 minutes before you walked in. She used the word, I had to prod it out of him, the treadmill. I needed to press him. Those are the words she used in order to get information out of a 6-year-old child. Corey actually originally told her he hit his head playing football on the turf. We know he was playing football. We have testimony that he was playing football. He was at football tryouts that week, so we know he's playing football. Officer Roman confirmed that he's seen him playing football. She's prodding a 6-year-old based on what? And this is what's important. And this is what Dr. Bodden testified to, and Dr. Andrew testified to, and Dr. Feingold testified to. She made her questions and decisions based upon information that who was giving her? Who was giving her that information? Brianna. Brianna, the person that is looking to get custody, went to a court to get custody, didn't get custody, and instead of doing what the court said to do by taking them together, she decided on her own, you know what? Let me take them to the pediatrician now. Dr. Deacon testified. Brianna stayed in the room the whole entire time. She got the history from Brianna. Do you think that Brianna in her history told her that she was in the process of cleaning up? Do you think that Brianna in her history told her that she's still taking methamphetamines? Do you think Brianna, in giving the history to that doctor, gave her any of that information? Do you think that Brianna told her that I had Corey on the 23rd. I didn't say anything. I watched him at football tryouts on the 28th, the 27th. Do you think that Brianna gave that to Dr. Deacon? She didn't. How do we know that? It would have been in the record. There'd be a record of what Dr. Deacon was told by Brianna. Just like it would be in the record that there were bite marks to the top of his head, and the chart she made, there would be bite marks. Dr. Deacon confirmed, and this goes back, by the way, now to treadmill, and child abuse. This goes back to that. She confirmed that he did not appear in any distress, and that he had multiple bruises in varying degrees of time. She did not indicate on her chart which bruises were from a treadmill, which bruises were from a football practice, or, as she stated, what bruises are from a 6-year-old child. The 6-year-old children fall, bump into things, and do stupid things. She testified that he had normal bruises. She testified to this. Normal bruises you can explain with falling and playing like children do. She did notice a fresh scratch on his belly button because it was still moist. Well, who had him? Brianna had him. So how did the injury to the belly button occur? And by the way, I'm not saying that Brianna abused his child, but I'm just trying to show you that he's a 6-year-old child. And he had a fresh abrasion on his belly button while in her custody. What does she do next? Dr. Deacon tells her, I want him to stay. I want to do further studies just to make sure he's got no underlying injury under his skin. So we'll take him by ambulance or whatever, I guess to Jersey Shore. I forget what hospital. Like I said, it's your memory, that's right, not mine. I believe it was to Jersey Shore. And she said, no, I'll take him myself, which is fine. She wanted to take him. She thought it would be quicker. It's her son. So she takes him to community health. They do an exam there. And what happens at the end of that exam? They want her to take him to Jersey Shore. And she says, I'll take him. Again. And this is important. It's important because if he goes by ambulance, who are they speaking to? Corey. If she takes him, who's conveying a history? Brianna. She needed to be in control of every one of those medical visits. If she controls the medical visit, she controls the narrative. And we get to meet Dr. I think I'm pronouncing his name right. Remember him? I think Ms. Ferrante did the cross-examination of him. I believe he did the wrong calculation for blood pressure. His blood pressure was actually high. He didn't know that he had done the wrong calculation until Ms. Ferrante, a lawyer, pointed out to a pediatrician, doctor, that he had done the wrong calculation on calculating his blood pressure. But Dr. Ong said something else. He was a very scary little boy. That's what he said. Very scary little boy. What 6-year-old child that has now been to 3 different medical facilities, it's now close to midnight, he's going from hospital to hospital to hospital, he's being pressed, he's being prodded. What 6-year-old kid is not going to be scared? What was going through Corey's head? What's going through his head? Why is mommy taking me to all these places? Why are they asking me all these questions? What I can tell you is that that kid was probably exhausted. What happens when you're tired? Your immunity goes down. What happens when your immunity goes down? You get sick. And what do they want you to do in a hospital? They want you to wear a mask. Why do they want you to wear a mask? Because there's infections and diseases and bacteria and stuff in hospitals and medical centers. So this little boy, in a matter of 12 hours, is in 3 different medical facilities, and he's exhausted. His immunity is compromised. Let's get back to child abuse. Dr. Ong determined that he saw nothing unusual, nothing, his words, nothing unusual. That the bruises were bruises. There was nothing unusual about Corey. He was in fine condition. He did state that he saw some bruising that he believed was made within hours. He did state that in his report. And once again, who was with him in those hours? Brianna. And once again, I'm not telling you Brianna's abusing this child. I'm not. But I'm saying 6-year-old boys, they bruise. He has scratches at his navel, and now Dr. Ong is finding fresh bruises on his body that he said were caused within hours. So now we have bruises from football, bruises from treadmill, fresh scratches from Dr. Deacon, fresh scratches from Dr. Deacon, fresh bruises from Dr. Ong. So how are you now? You're supposed to do this. How are you going to differentiate what bruises and scratches and contusions were caused by a treadmill, were caused by football, were caused by a 6-year-old being a 6-year-old? Not one doctor gave you any of that information. Not one doctor. Not one doctor said there was anything wrong with Corey. 0. How could you possibly form an opinion for child abuse if we can't even discern a particular injury afforded to that treadmill activity, let alone murder? Murder. What else did Dr. Ong tell us? He said that a child is different. Child systems are different than adult systems. They run at a higher metabolic state, and that they de-escalate very quickly. Dr. Bodden testified yesterday. Dr. Bodden, who has been doing this for maybe 300 years, but Dr. Bodden came here and he testified. He's testified for the government. He's written publications and given lectures on child abuse, forensic pathology. He agrees with Dr. Ung. Children de-escalate very quickly. Very quickly. And Dr. Bonin actually talked about pediatricians. Pediatricians are not forensic pathologists. Pediatricians treat children. Pediatricians don't do things like a forensic pathologist does. They don't do things like Dr. Feingold does. You go to a pediatrician, he looks in your ears, he looks up your nose, he looks down your throat, hits you in the knee a little bit, takes your blood pressure, does your heart rate, takes your pulse. You got any complaints? Feel good, doc? You're good to go. They don't do anything other than that. Dr. Bonin testified to that. A pediatrician is a doctor of treatment. A forensic pathologist is an expert on death. So what does Brianna do next? She takes him home to Jamesburg. We see the picture of her bedroom. She's got two beds in the bedroom. She testified that he slept with her that night. Now, that's not so innocuous. That's really not so innocuous. When do children most likely want to sleep with mommy? When they're not feeling well. That's when they want to sleep with mommy. So it's not so innocuous. Just like her refusing to have somebody take him, Corey, from one place to another. That's not so innocuous either. That's her controlling the narrative. A narrative that she needs to control in order to finally get her child. So what does she do the next morning? As a parent who just traipsed your son through the whole night from doctor to doctor to doctor because you believe your child is abused, who went to court to get an emergent order because you think your child is abused, what does she do? She takes him to Christopher. So how concerned was she really? How concerned was she really that he was abusing him? This is all her narrative. I see a light. I could finally, he's 6, I may finally be able to have custody of this little boy. She brings him to Christopher. Oh, it would have been a violation of a court order. She's already violated the court order when she took him to the doctor without him. The court order was you and the baby's father are to take the child to be evaluated by the pediatrician. And even if she's violating a court order, if you're a parent and you think your child is being abused, do you give him to the abuser? No. So how serious was she? This is all just a ruse. There's a way for her to finally get custody of this kid. Excuse me, Corey. And it gets better. It gets better. At 3:30 in the afternoon, she testifies, or she testifies that he calls her at 3:30. Corey is lethargic, Dr. Bonnet, sign of infection. Corey's legs hurt. Corey's been sleeping all day, throwing up. I need his insurance cards. What's the next thing she does? She calls up or texts on Facebook Messenger her ex-boyfriend, and I guess drug dealer, Justin Vondren, and she asks him to bring her a bump. Not, oh my God, the baby's father just called me and my child is sick and he's taking him to the hospital. May I get a bump? I didn't even know what a bump was until I asked her, and she was gladly explained that it's methamphetamines. It's drugs. And you snort it. That's what she was interested in. I'm going to use that word. Talk about under-emoting. That's the ultimate under-emoting. That's not Mommy of the Year. That's not, I'm so concerned about child abuse. That's, let me get a bump. And was that it? No. Moments later in the same conversation, 15 minutes later actually, I'll get it myself. I just don't want that much. 10 minutes later, her son is in the hospital. 10 minutes later. Back to Justin. I asked you for a bump. I don't know if you could add inflection to Facebook Messenger. I did. Are you coming here or am I going there? Brianna says this, you need to come here. 4:38. Hurry up. Do you think when she was making emergent orders to judges to get custody of Corey, she was including in the order that she's bumping it up? Do you think she included that information in the order? Do you think when she met with Dr. Deacon, she told Dr. Deacon she's bumping it up? Do you think when she met with Dr. Ung, she said she was bumping it up? Do you think for 1 minute that had she told any one of those doctors, that any one of those doctors would have said, here's Corey, go home with him? No way would that have happened. So she excludes that in the history she gives to the doctors. She testified that she started calling hospitals to find out where he is because supposedly he's not answering her. Well, he's in the hospital with his son. We're going to get to this hospital. He's in the hospital with his son. We had Sergeant Coles testify. I actually even called him. Sergeant Coles testified to the Celebrate and phone calls and hundreds of phone calls and text messages, and internet searches, and yada, yada, yada. Did we have any of them come in and say, hey, Sergeant Coles, did you check, Brianna gave me the cell phone. Did you check Brianna's cell phone to see if she called all the hospitals in the area? Who cares? We know she was more interested at that point at snorting methamphetamines while her son was in a hospital. that she knew about. He told her that. He told her what was going on. He didn't willy-nilly just bring him and say, let me take him to a hospital. He called the mother. He's sick. He's lethargic. She had nothing to do with Corey's death. Nothing at all to do with Corey's death. He had nothing to do with Corey's death. That death was exactly what Dr. Von testified to. Corey died from natural causes. But do you think for a minute that if those 3 separate medical facilities were given accurate histories by Brianna, accurate histories of why she was there, instead of them focusing on, is this child being abused? Are these bruises from abuse? Are these abuses from football? Are these bruises from a 6-year-old running into a wall? Do you think that maybe they would have taken a different approach? Do you think they might have said, let's look at this, look at that? But no. We were getting a history from her. This is the same person that DCP&P relied on. This is the same person that she called, DCP&P called and sent her to doctors. Do you think that she would still have custody? Or visitation, for that matter, if they knew she was bumping it up? Every single doctor, even their experts, Dr. Bodden, said one of the most important things is taking a history from someone who is lying or giving an inadequate history. It's not going to be helpful to a diagnosis. Your job is not to judge her. His Honor is going to give you a charge. It's a credibility charge. It's whether or not you find her testimony to be credible. And he's going to explain in that charge that if you find her testimony to not be credible, that you can disregard that portion of her testimony, or you are free to disregard all of her testimony. Well, if you disregard the portion of the testimony where she's not telling the truth to a judge, to DCP&P, to Dr. Deacon, to Community Health, I don't remember seeing a doctor from Community Health either, to Dr. Ung, well, that's why you're jurors. You get to make that decision. And while I'm here, after Corey passes, she and her family become a one-man wrecking crew. They go crazy. I can't make this up. I was actually reading this last night. She testified that she woke up one morning, and I believe it was her mother, and a friend. I may be mistaken, but it was at least her. that she wakes up one morning and they decide, well, I think it's Saturday morning, instead of maybe going to see Corey at his grave, going to church, working on my sobriety, let me go to the local supermarket, let me buy dead fish, ham hocks, and goose egg stones. And let me go to Dave Gregor's house, because I think that's a great idea. I think it's a great idea. To now run to Dave Gregor's house and throw dead fish, ham hocks, and goose egg stones at his house and on his lawn. Is that normal? Is that something you would expect from somebody who is grieving? And look, everybody grieves differently, and I'm going to get to that. But I don't think that grieving is waking up in the morning and buying dead fish, ham hocks, and goose egg stones and throwing them at somebody else's house. Who does that? Maybe somebody bumping it up thinks it's a good idea. That could possibly be the reason. And she starts a GoFundMe page. GoFundMe. Justice for Corey. And then an administrator, you know what, I don't think she set up the GoFundMe page. I think an administrator on the page set it up. She was one of the administrators. I believe she testified that she knew it was set up. And she testified that she did profit from the GoFundMe page. She profited from her son's death. And GoFundMe became very expensive because they have fees attached to them. So they decided in their infinite wisdom, we got to increase the profit here because GoFundMe is taking too much money for us, so let's set it up as Cash App. And what did she say she used the money for? She used the money for burial, she used the money for funeral costs, and she used the money for court. I don't know what she had used the money for court for, but she used the money for court. Now we come to the drop-off. So she drops Corey off, and I already went through why is she dropping him off here, but she does, to Christopher's house at about 9:02, 9:03. And at that time, she accidentally, never did this before ever, but accidentally videotapes a conversation between her and Corey. Can you play it, please, Ms. Roger? May I, Judge?
Certainly, it's in evidence.
He's your other parent, so it's his right. He needs to see it because you went to the doctor, and I just want to make sure he sees that, okay? I'm not sure where he is.
Stop it.
Counsel, I thought we agreed you'd hit play a second time. I think the first time it starts, ladies and gentlemen, doesn't seem to capture the beginning. So, Ms. Ferrante, could you just play it a second time?
No, I asked to stop it. There was a reason I asked to stop it.
You could do
Yeah,
it.
he's inside. I don't know why the car's not here. That's strange. Yeah, see? Well, he's your other parent, so it's his right. He needs to see it because you went to the doctor, and I just want to make sure he sees that, okay? I'm not sure where he is.
Stop it. Dr. Andrew, did you hear Corey moan in that 33-second video? No. Dr. Feingold, did you hear Corey moan in that 33-second video? No.
Yeah.
Dr. Andrew, did you hear Corey yawn in that 33-second video? No. Dr. Feingold, did you hear Corey yawn in that 33-second video? No. This is in evidence. Go back. Go listen to it. He moans and he yawns. And I'm going to get to the diagnosis you're making on the video. So you got to say to yourself, how does she accidentally take a video that she's never taken before, just so happens to take the video the night she's going from hospital to hospital to hospital, violating a court order, telling doctor after doctor after doctor what's going on, going home, trying to get bumps. What's the one thing that's missing on that video? Them. You don't see Corey. You don't see Brianna. And I'm telling you right now, that was no accidental video. When you walked through that door, the judge didn't instruct you, hey, leave your common sense out there. We picked you because you have common sense. That was done on purpose. On purpose. Trying to set up another, all right, judge said no, doctor said no, let me do a video. And on purpose. We don't see Corey, we don't see Brianna. That's on purpose. I think it was 8 words. At one point in the trial, I said 13. I went back the next day, I counted it, it's 8. You got a transcript, you counted. Dr. Andrew, a forensic pathologist who works on dead bodies, modified his time frame where the blunt force injury occurred on a 33-second video where the child says 8 words. He doesn't hear him moan, he doesn't hear him yawn, but he's able to move that trauma to a time frame of when he's the only person who had control over Corey. Because if he doesn't move that time frame, guess who else is in the middle of it? Brianna. 1 year later, a forensic pathologist, and I'll get to him, but I'm there. Forensic pathologist that they got in New Hampshire. They didn't call their own medical examiner. The person, Dr. Ragasa, who did the autopsy. But they go to New Hampshire. He gives them a report. The report puts it right in the middle of the two of them. Well, we can't have that. Let's give him the video. Let's give him the picture. Do we have the picture, Miss Ferranti? On the couch? Is that the picture of a man who either just beat his child, is in the process of killing his child, or is at this moment planning on, all right, let me take this picture, and I'm going to get to this picture. Let me take this picture now before I beat my son. Let me take this picture now before I kill my son. So their doctor from New Hampshire comes here and says, that picture, that 33-second videotape without any people in it, except voices, gets him to modify his opinion and rule her out, and puts the target completely on him. And a year later, we see him arrested. I believe Ms. Ferranti had the office here yesterday of him getting arrested. And we can get to that. So, let's talk about Christopher for a little while. Between March 20th and April 2nd, March 20th is the point where we have the treadmill. 4/2 is the day court passes. So who do we hear from first? Kim Peace. Kim Peace was the lovely school teacher. She comes here and testifies that she saw a bruise. She was upset, or another teacher saw a bruise. They discussed it. They decided that they were going to contact GCPMP. They were going to do whatever they needed to do. This is the same teacher, and it's in evidence, that wrote a lovely little letter for him, making him out to be the father of the year. The same teacher that now says that he wore long sleeves on a hot day. Okay? Maybe he was cold. And indicative of child abuse, because he wore long sleeves on a hot day. By the way, he was in school the week after treadmill. He didn't have long sleeves on then. If they were trying to say he's trying to hide his abuse, wouldn't he have had long sleeves on him then? Wouldn't he even kept him out of school then? If he's abusing his kid, like they want you to believe, he would not have sent him to school. Or if he did, he would have covered him in long sleeves. He didn't, because he's not abusing his kid. The other thing is, they talk about this vacation to Key West. And you have the class dojo. I believe it went into evidence. If not, I'll explain it to you. He says to her, we're going on vacation to Key West. My family is going on vacation to Key West. After he says that, he then says, we will be appearing virtually. Is there anything else I need to do? And on cross-examination, I didn't know that he meant that he would be appearing virtually. He says it right in the class dojo. He wasn't looking to keep his son out of school for a week for spring break, I think, and then the family was going to Key West. By the way, if you're about to abuse or murder your kid, are you doing it right before you're taking him on vacation with your family to Key West? No. They had a system. Thumbs up, thumbs down. She testified. She very rarely gave a thumbs down if Corey had an issue, which were few. She would go on Class Dojo and let him know about it. She also testified that Brianna never communicated with her. He did all the assignments. He was a good student. He was on time. And he was always dressed appropriately, I guess except for that one day that he wore the long sleeves on a hot day. There was a reason he was the residential parent. And you see that through Kim Peace. He's a residential parent because he's taking care of this child. He's got a network. He's got his father, his mother, 3 siblings, one of which lives down here in Barnegat. He has a network and a support system. He's got a master's in education from Johns Hopkins. He's teaching children in the Baltimore inner city. And that's why he's got residential parenting. He appeared virtually every single time he was supposed to. And this is a theme. Every witness comes up here and just changes things. You have a letter that you say is parent of the year. They come in here and now he's not parent of the year. You have all these issues that were non-issues, and now all of a sudden Corey passes and now he's an ogre. They got to make you try to, I mean, I say this and I hate saying it because it's such a color, whatever it is, but you're trying to fit a square peg in a round hole, and it just doesn't work. It just doesn't work. By the way, he showed up to school with the bruise. That's why they sent him to D.C. P&P. If he was hiding it, why would he send him to school with the bruise? He's not hiding anything because he didn't do anything. Now we're at April 2nd. Brianna drops Christopher off at Corey's. Prior to the drop-off, we have the accidental reporting. And we learn that he, through Sergeant Coles, we learned that that whole morning he's in communication with a woman named Marcy. That him and Marcy are talking back and forth about getting together. She asked Marcy about how's Corey? Is Corey all right? One word, yeah. Not. Oh, he's sick. He didn't say that. Yeah. Just got home. I don't know what kind of evaluation he could have made, but the answer to Marcy was yeah. So, as he's speaking to her through the whole entire day, there's a conversation, according to Sergeant Coles, back and forth between them. Pizza. Do you want me to get pizza when I come over? Do you want me to bring a deep dish? Do you want me to do this? He's making arrangements with this girl, Marcy, to come to his home. to hang out. So, if you are abusing your child or going to kill your child, are you inviting a witness? Are you inviting Marcy to come over and share pizza with you? A person that could sit there and visually see your son? You're not doing that. Because you're not abusing your child. Use your common sense. None of it makes any sense. Bottom makes sense. $11:53. He texts Marcy that he's asleep. Corey's asleep. It's 11:53. Takes a picture of him still sleeping on the couch, which I just showed you. That was at 2:02. Like I said, is that a picture you're taking of a kid you're about to kill? Is that what you're going to do? Is that the picture of the kid you're about to abuse? Did it look like he was abused already? We know Corey throws up and he defecates himself. The CSI detective testifies that he smelled the vomit in the house. And they make a big deal about the clothes in the garbage pail. Clothes in the garbage pail. The defecated clothes are in a garbage pail underneath a McDonald's bag. They made a big deal about it. He's a guy, and I hate to be a sexist, but a guy who has a 6-year-old and his kid did poopy in his pants and his underwear and soiled himself is not cleaning that stuff. He's taking it and he's throwing it into the garbage pail. And if he was going to hide it, would he have just put the McDonald's bag on top? Doesn't he think that if he's in trouble, that if he abused his child, that if he killed his child, he would put a McDonald's bag on top of the defecated clothes? No! It's ridiculous. He's ordering McDonald's to feed his child. If you're killing your kid, are you feeding him first? We know that Corey gets very sick very fast. Very sick very fast. Dr. Ung said it. Children decompensate very quickly. We know he calls Brianna. We know he drives him to the hospital. And he stops right in the middle of the emergency room. Right in the middle of the parking lot, basically. Picks him up. He's not meandering into the emergency room. Goes in the emergency room, and what's the next thing we get? We get Nurse Doyle. Watch this now. This is amazing at how long it takes anybody to help. Here it comes. Tries to put him down, and it ain't gonna work. Trying to talk to somebody to get some help. Daddy holding his son. Does that look like under-emoting to you? We still don't have Nurse Doyle. Still, standing there with this child. Does it take a doctor to see that that child's in distress? Concerned about making sure that they are identified and they have their stickers on them. Southern Ocean Methodist Memorial Medical Center. Now we see Nurse Doyle. Now, is Nurse Doyle doing anything to see Corey? Where's that video? I couldn't see his face. Couldn't see his face. He's a nurse. Go around the other side of Christopher and take a look at his face. In hindsight, you want to just yell at Doyle and say, do that. Still leaving him in the middle of the ER, that child in obvious distress. Moments matter. Still no help. Under emoting? Now we get him to bay number 6 after 4 minutes and 16 seconds. It took Southern Ocean Medical Center 4 minutes to render that child who was in obvious distress any aid. Any aid. The nurse said I couldn't see his face. Well, walk around, Christopher. Take a look at his face. You didn't need to look at that child's face to know that that child was in obvious distress. Well, he told me he was at the hospital the day before and they released him. So what? So what? This is what was presented to you. Get him in the back. Now it's all hands on deck. He told us, Nurse Doyle, that he was pale. Bottom said sign of infection. Lethargic. Bottom said sign of infection. He had agonal breathing. I don't know what that is, but I guess that's not normal. Baden said that the breathing would be disturbed. Doyle noted all of those things. All. Now it's all hands on deck. They take Corey into the back. I believe it was room 6, I said. He goes into distress. They intubate him. And they begin to do CPR for 49 minutes on a 6-year-old. 49 minutes. They bring him in to say goodbye. No, he didn't wait for the doctor to go, all right, time of death is 5:03. They brought him from the room they put him in. The patient waiting room. Oh, Lindsay Carnivale, she just cracks me up. I'll get to her. But why do we have patient waiting rooms if that's not where the parents are supposed to sit or family is supposed to sit? We have them so you sit so they could do their job. So you're not in their way. Do you want to see your loved one intubated? Do you want to see your loved one having CPR performed on them? At 6? So they took him out of the room and they put him in a family waiting room. That's odd. According to Lindsay Carnivale, that's odd. Corey dies. Did anybody officially go, all right, time of death? No. They bring him in to say goodbye. He can't even get in the room. Look at him. Look at him. That's what they call under-emoting. They had to get him a chair. He's inconsolable. That's not a man, oh my God, I killed my child. That's a man, oh my God, my child is dead. Lindsay Carnivale, he lacked emotion. He under-emoted. He was clinical when he gave a history. Because he was calm. When he gave a history, he was calm. When he explained to the doctors what was going on, he was able to put himself together and say, Doctor, this is what's happening to my child right now. Please help him. Did she want him to be one of these parents? Oh my God! Help him, help him. No, he was calm. She got upset. He was calm when he gave his history. Was that calm? Was that under-emoting? Was that emotional? His oxygen level was 85%. Dr. Bottom. It's very low. Should be about 97. Sign of infection. Sign of a breathing issue. Lindsay Carnevale. We might have put the pulse ox on his finger wrong. Are you kidding me? Are you kidding me? Are you kidding me? You're giving him CPR, you intubate him, and you're telling us, the jury, and the people here, well, the oxygen level was low because we put the pulse ox on wrong. Come on. Dr. Bonnet, loopy, hypoxic, all signs of low oxygen. Medicine, science, not text messages, internet searches, phone calls, Facebook messages, medicine, science. So, blunt force trauma. The argument is that he beat that child to death by blunt force trauma, that the trauma he incurred on that child left no bruising, but we could see it underneath in the skin that there was bruising. So we had, I guess, invisible bruising. That's the blunt force trauma. With such force that he lacerated his heart and his liver, although even Dr. Andrew agrees that the liver had nothing to do with the cause of death. So let's think about that for a second. We see a red mark on Corey's chest. Every doctor testified to this circular red mark on his chest that occurred when he was in the hospital. They all agreed that that is not a bruise. That was from a medical device or a pad. So you're telling me that a pad that they put on this boy when he got into the hospital left a bruise, but the blunt force injury he caused, we can't see. It's not there. It's not there. It's inside. It's inside. It wasn't the chest injury. The chest injury happened 12 days prior. Every doctor testified to it. Deacon noted it. Og noted it. Andrews said it had nothing to do with his death. So, where is the injury that he did that caused Corey's death? There is none. None. Corey died from an infection. A rapidly growing, spreading infection. Whether it be pneumonia, which he thinks is over 50% chance, is what he told Ms. Lento. He did not die from a homicide. he died from natural causes. This is Dr. Bottom. He reviewed all of the medical records. He reviewed all of the information necessary to make a medical diagnosis. No, he did not review the Alcoa, Tennessee roadside videos. No, he didn't review Kim Peace's class dojo. No, he didn't read the text messages between him and Brianna. But what he did look at were all of the medical records. Dr. Bond, a person that the government called to reinvestigate the assassination of John Kennedy. Martin Luther King. A laceration that size, he would have been dead in moments. There's no way he could have died in that home, drove him to the hospital, went through whatever they did to him in the hospital, that's another, whatever they did there. Where did he go? Big deal. We spent days on him leaving. Days on him fleeing. You know why we spend days on him fleeing? Because if you were thinking about him fleeing, you're not thinking about the medical records. You're not thinking about the things I just spoke about. You're not thinking about the fact that there's no injuries. You're not thinking about it. You're like, oh crap, why did he go to Arkansas? Who cares? He did go to Arkansas. He did. He got in his car and he drove straight through. He turned off his phone. He didn't want anybody to find him. He wanted to be alone. He was grieving. And I don't know a single person in this room that can tell somebody how to grieve. His grieving was to run. If he was leaving because he was guilty of committing a crime, when he got stopped in Alcoa, Tennessee, and he gave them his car and telephone, oh, they had warrants. They didn't know that they had the warrants yet. He gave it to them. And they let him go. So now you think to yourself, if I'm guilty of killing my son, or I'm guilty of beating my son, and they've now taken my car, and they've now taken my phone, skedaddle, I'm out of here if I'm guilty, right? So if he's guilty, if the reason he left was because he had the consciousness of guilt, that's when he would leave. That's when I'd go. They take my car, oh, wow, they're right on me. And by the way, when he comes back, he isn't arrested for the endangering for 4 months. He could have been in Montenegro by that point. He stayed. When they wanted him, he was hiking in West Virginia. They called his father and they said, we want him to surrender at 9 o'clock in the morning. Dad, I can't. He's in wherever he was, West Virginia, hiking. Well, if he's not here at 9 o'clock in the morning, that's an issue. Dad called Hertz, tells them, well, wherever he called the car rental place. Stay open late. I got to get my son here. He drove throughout the night, not knowing what he was going to be charged with. Consciousness of guilt? Consciousness of guilt? Is that a guy that's guilty? That's a guy that says, here I am. And then they only charged him with endangering the welfare of a child. They don't even charge him with the murder yet. So for almost a year, with the endangering hanging over his head, then you saw, please. Yes, please. How many police were there? I don't care if there were 5,000. I don't care if they brought the whole South Pacific in there to arrest him. He stopped, put his thing down, complied, and what was important to me was, yes, sir. No, sir. Okay, sir. They wanted him back. He came back. They wanted to arrest him almost, it might have been a year later. They arrest him again for the murder. Fleeing? Fleeing? Grief. His 6-year-old kid just died. He left to be by himself, to grieve, to cry, to be upset.
Mr. Gallucci, we're almost 2 hours. The jury probably needs a break. Yes, we're
No.
5 minutes short of 2 hours, yeah. So
I don't really have...
well, you want a couple minutes to go over everything, ladies and gentlemen, take a short break, and then maybe we'll take a late lunch after Mr. Gallucci finishes. I mean, I just know you've been sitting in those chairs for almost 2 hours. That's a long time. So, again, don't discuss anything about the case. Going to wait for everything, both sides of my instructions, but take a little break in the jury room and we'll bring you back. I'm sure my reporters need a little break too. Blood was in my legs again.
One sentence, right?
5 minutes short, 2 hours.
I feel like I was listening for
All right, please be seated, everyone. Thank you. Unless you need to stretch your legs, which is understandable. So I'm not going to hold you to an exact time limit, Mr. Bellucci, but how much longer do you think you have?
So that was 22 pages, and I got 36 left. Judge, I have about 4 pages left.
All right. So then the plan should be,
And like, the end is, keep it open mind.
right. All right, so I think the plan would be that we take a lunch break, come back and do the state summation after lunch. Well, right now I'm on the record. I don't know if council has anything outside the presence of the jury. I want to address some people in the audience, though. When some people left, but when a sheriff's officer tells you to move, you move. Several of you did, but one of you didn't. And it was a distraction during Mr. Bellucci's testimony, and the only reason I'm calm right now is because it was like an hour and a half ago. But I almost stopped him because I saw Officer Kennedy telling someone to slide down and someone arguing like they were entitled to a particular piece of bench. And it's inappropriate to do that. I wouldn't let it happen during the state summation. I wouldn't let it happen during the defense summation. When I was a defense attorney or when I was an attorney, I tell you what, the judge would have the sheriff's officer drag you out of the courtroom for doing that. Sheriff's officers have control of the courtroom. You follow their directions. It's a criminal offense to refuse to comply with the direction of a law enforcement officer. And when the officer tells you to move down, you don't stand there and argue with them about it. So fortunately, the jury didn't seem distracted by it. They seemed to be paying attention to what was going on. But it's uncalled for. And all those people that did listen, and most of you did, I thank you for that. But the officers here, they run this hearing of the courtroom. And when they tell you to do something, you need to follow it. We'll take a few minutes. I need a break. I'm sure the court clerk and the court reporters need a break. The sheriff's department will determine whether they close the courtroom or not. Back on the record, the jury's still in the jury room. We're going to give them another minute or two. Anything from counsel outside the presence of the jury?
No, thank you, Your Honor.
Thank you.
Came right back, like a year later, they arrested him again for the murder, flaying free. His 6-year-old kid just died. He loved to be by himself, to grieve, to cry, to be upset.
We ready?
All rise.
12:39. Jury's out.
Here we are.
Thank you. Please be seated, everyone. Mr. Galucci.
So I once saw a play, and in the play they had to stop it, and all the characters just backed off the stage, and when they walked back in, they started at the exact word that they had finished with, and they just picked right up. Unfortunately, I'm not an actor, so I can't do that, but I'm back. So, where was I? I was talking about him fleeing. Well, their word, fleeing. My word is left. Fleeing and leaving are two different things. Fleeing is meaning I took flight. I went somewhere to avoid something. Leaving is I left because I needed to go. And that's what he did. He left. And I just discussed with you that had he wanted to go, he had every single opportunity to go. And he didn't, because he's got nothing to hide. He didn't do anything wrong. And how do we know that? We know that from a number of reasons. We know that I don't think that they've proven their case beyond a reasonable doubt. As a matter of fact, I don't even think they're close, but I'm biased. Dr. Bodden talks about blunt force trauma. And he talks about the blunt force trauma that was incurred during the vigorous CPR for 49 minutes. And he said to you, he said, CPR is supposed to be vigorous. You're dead. If you're getting CPR, you're dead. And they'll do anything to try and get you back. And one of those things they need to do is to compress your heart by pushing down on your rib cage against your backbone, your spine, pushing into the heart to compress it. And they did that for 49 minutes on a 6-year-old child. And I'm not saying that whoever did the CPR did it wrong, although Dr. Bodden did say that it was much longer than it probably should have been. I'm not saying that the CPR killed Corey, because it didn't. But what they're trying to tell you what did kill Corey had absolutely nothing to do with him, and it was all CPR related and how, we don't need to listen to Dr. Bodden. He was paid by me. Their expert was paid by them. Guess who wasn't paid? The medical examiner, Dr. Ragasa, the guy that actually did the autopsy. The person that when he did the autopsy noted in his findings, C, injury, CPR, related. Related. Their medical examiner, Dr. Ragasa, who didn't testify here, the only one that doesn't have any skin in the game, he's the one that indicated that the injuries to Corey's heart and liver were possibly as a result of CPR-related injuries. Dr. Bodden testified that he's done lung and heart internships and residencies. He's done that. So not only has he worked on dead people, but he's worked on live people. And he has seen these injuries. He says it happens all the time. Does death happen all the time? No. Does CPR cause death? No, you're already dead. I asked that stupid question. Well, could CPR kill somebody? And he said, you're already dead. If you're getting CPR, you're dead. So an injury to a rib, an injury to your spine, doesn't really matter. That's superfluous to what lies on the other side. So let's talk a little bit. I really don't want to get into it, but I'll get into it a little bit because I know you want to hear a reason. These searches, the searches he made. So everybody searches things all the time. All the time. On your computer, on your cell phone, or whatever. And he deleted searches. He deleted all his searches prior till April 2nd. All. So now, if you're going to say to yourself, but Mario, why would he delete all the searches? I don't know. I can't answer that question. But if you were going to delete searches, right? If you were going to delete the searches that are going to hurt you, would you leave the searches in there that are, can my car be tracked? Can my cell phone be tracked? The searches he made about how long until an arrest after an autopsy. Does blood sugar show X? Does a rise in blood sugar do Y? So if you're going to delete searches because you're hiding your criminality, wouldn't those be the searches that you want to delete? They're not. They're there. This is an absolute tragedy. There is no words for the death of a 6-year-old child. When we met you, when we picked you, we told you the type of case it was. We told you what you were going to see here. We explained to you what this was going to be, and you promised all of us that you would take the emotion, set it aside. That's going to be hard. He's 6 years old. It's going to be hard. But you have to. And you were chosen because we all believed you would be able to do exactly that. Now, if you do that, and you just look at the facts, the science, not the superfluous stuff, searches the fleeing, the superfluous stuff. The science, the medicine, the medical examiner, the doctor's testimony. If you just look at that, there's only one conclusion you could make. And that's the same conclusion Dr. Baden made. Corey died from natural causes. This is not a homicide. No matter how hard they're going to try to stick this square peg in this round hole, science is science. And Dr. Baden explained it to you exactly the way it happened and why you have it. Is it tragic? Hell yeah. Sad? Yes. There's no winner. She's sitting here crying. He's sitting here crying. There's no winner here. Corey died. That's it. Nobody had anything to do with that. So now I'm done. All right? Some of you may be really happy about it. Some of you may want to say, yeah, let's come back tomorrow and hear Gallucci do this all over again. I doubt it. But let me explain something to you. You're never going to hear from me again on this case. You're never going to hear from me again. So I talked about this earlier, the judge actually did. There's something called primacy and recency. They go first, as you saw in the beginning, and they go last, which you're going to see momentarily. So I never liked that, but that's our system, and that's what I have to live with. So I want you to do me a favor. I want, after they're done, and you go back and you deliberate, and you always remember what was said to you last, I want one of you to say, all right, I don't know which one of them is going to do the summation, but when you go back there, and whether it's Ms. Schran or Ms. Lento, and you're arguing back there, and they say, oh, Ms. Schran or Ms. Lento said such and such, I want one of you to turn around and say, all right, what did Gallucci say about that? Because everybody here spent a lot of time. Deliberations are exactly that, deliberations. You're supposed to go in the back there, you're supposed to look at the evidence, you're supposed to make decisions, and you're supposed to deliberate. And that's all I ask. Although I'm telling you right now that when you're finished, when you're done, there's only one verdict that I believe you can come up with. And that's that Christopher Gregor did not kill or abuse Corey. Thank you.
Thank you, Mr. Gallucci. Anything from this state before we break for lunch?
No, Judge, thank you.
All right, so ladies and gentlemen, I'm going to release you for lunch. I'd ask anybody here who's a spectator, please respect the jurors' privacy during lunch. If you find yourself in the same restaurant, please try to avoid sitting close to them. If the place is crowded and you get a seat close to them, then I don't want you discussing the case. I don't want you making comments that are potentially overheard by the jurors. I need you to do that. The integrity of the process is important the entire time, especially important now. We're in the middle of summations. So, ladies and gentlemen, you can clearly go to lunch together, you can clearly go to lunch alone, whatever you prefer. We used to have a cafeteria across the street, a coffee shop downstairs, so I didn't have to worry about you going down the street, and you'd stay in the court complex, but somehow or another those are all closed. As I said to you, you can't get a bottle of water here unless we give it to you in the jury room, which is sad, but it's the reality. So please leave your juror badges on. Don't let anybody come up to you. If you feel someone's coming up to you or saying something to you, or even staring at you, making you feel uncomfortable, report it to us or any sheriff's officer you see in uniform right away. Continue to follow my instructions. Don't start to discuss it now. The only time you're allowed to discuss and deliberate is going to be in the jury room, and you have to hear the state summation and get my charge. So don't be tempted to start saying things now. Just continue to keep an open mind and wait for everything to be over with. Don't do any research. Don't predict how long. Just avoid discussing it with friends or family. You have to. Simply that we're still in the trial. That's it. Please report back to jury assembly, say about 2 o'clock, I guess. It's an hour and 5 minutes, so we'll give you enough time to, I know it's tough to walk downtown sometimes, stuff like that, to get back in time, so we'll say 2 o'clock, and then hopefully we'll get done with the state summation, and hopefully able to get my charge through today, but we'll see how it goes. Anything from counsel before we excuse the jury?
No,
No,
you're
Judge,
right.
thank
All
you.
right, thanks so much, ladies and gentlemen. You can leave stuff in the jury room if you need to, or you can take things if you like.
That's fine.
We're gonna- we
I
might-
might add another slide to it.
Anything from counsel outside the presence of the jury?
No, Your Honor, I just asked if during lunch, I think they agreed, you agreed, right? Just to look through that PowerPoint, so this way we could dip Miss,
Sure.
let you, Miss Lento, just go right to summation. I can look at it.
Ryan, would you like one?
Would you like a copy, Judge?
Sure. If you have an extra, that's fine.
Yes, we do.
for
Thank
that.
you.
May I approach?
Yes, please. Thank you. Sorry. All right. Thank you, everyone. See you after lunch.
Thank you.
Please exit.
Lunch break without the jury present. The jury's in jury assembly. The state provided a copy of its proposed PowerPoint on paper to the defense and to the court. Anything from the defense on that?
Yes, there were approximately 16 different slides that the defense would object to.
60?
16.
16?
And Judge, for the record, if I could just add, on the very last slide, I told Mr. Gallucci, and I don't think he has an issue with it, I changed one of the words from goofy to silly because that's what actually came in. In addition to that, we added 2 slides over the lunch break that no one has seen.
Good night.
In their response, we discussed.
And I did discuss that last slide with Sharon, and I'm fine with it, but I thought we were fine with that slide to begin with.
We were.
Right. So, unfortunately, they're not numbered, right? At least not on the
They're
paper.
numbered on my computer.
Right,
It wouldn't be
but not on
numbered.
the paper.
Then the PowerPoint that we show the jury would be numbered if I did that. So.
All right. So how do you want to address this? Do you want to just count the pages for me and tell me what page you're on?
I did, Judge. That's exactly what I did.
Okay. Please tell me what the first page is.
It's page 8, and the caption is 2 hours late.
Yeah, the PowerPoint is not working now. It was.
Because I'm going to be handing out my copy of the ultimate report.
Right. Go. I have it. Go ahead. 2 hours late.
I just think the implication there is speculative, because they're suggesting that Mr. Gregor is holding up 2 fingers, and therefore there's punishment happening because of the 2 hours late. I just think it's just speculative.
Does that refer to the timestamp? Is that?
I need a second, Judge, because when
Oh, it's not
I
coming
just
up?
took it off the TV, now the pictures all disappeared out of my PowerPoint. Hold on. Everything's gone.
Your photos, you mean, are out of your copy of the PowerPoint they're gone?
Yep.
Oh, jeez.
It was all queued up and ready to go.
Well, you didn't have to take it off the TV.
Well, I had to be able to hit the escape button to look at the slides to figure out the 16 different things that we were going to talk about. All my pictures are gone. See?
John, what's the temperature saying?
In here, sorry.
What's the jury room, you know?
Yeah, I don't think that's what the issue is. The PowerPoint is messed up now. Pictures aren't there. Okay.
You're a star, Dan.
Thank you, Your Honor. I apologize for that.
All right. Slide 8. What's the 2 hours late refer to?
What does it refer to? It's an inference the state's drawing based on the evidence and the facts. Brianna, slide.
Right. Okay. So that was just not the timestamp.
No, it's not the timestamp.
Right.
It's a number 2, 2 hours late. He's been running for 3 minutes at that
Why
time.
don't you put a question mark after it?
That's fine, Judge.
Clarify, Judge, not to interrupt. Clearly, when they added the additional slide, my numbering is now off.
Right. Yeah. I know. That's all right. We'll work with it. All right. What's the next slide?
Next slide, I have marked as original page 10, and there's a mention of sweating as the caption. I just don't know what that's based on, and I'm going to object to.
The defendant's wiping his brow, Judge, so we can infer sweating.
I didn't see that in the picture.
That's an appropriate argument. I mean, you're both arguing what you think the evidence shows. It's an appropriate argument.
Thank you.
Next one.
Next one, original page 18. Yes, that one. And that is specifically the defendant is enjoying this look at his face.
He's smiling, Judge, if you look at his face closely. Smirking,
I mean, again,
smiling.
that's
Looks like joy and
that's
excitement.
that's an argument about what the state contends the evidence shows. It's based upon a photo that the jury can draw its own conclusion about whether it's accurate or not. That's overruled. The next one.
22.
That was 18 we were on?
And the last one was 18. Now I'm on 22, and I'm pretty sure that's being shown on the screen.
Cootie. All right, that's not.
And the objection is the yelling. I don't believe there's testimony to that effect.
Judge, we'd ask that the jury could infer from the photographs, but also the fact that they watched the video, and if they need to replay it, they can ask to watch it again, because it's evidence in the case that by the defendant leaning in and moving his body as if he's yelling, we can make the inference that he's yelling. We can't say what he's saying, but we can make the inference that he's doing all of the things that one would do when they yell.
Judge, I don't think it's an appropriate argument. There's no audio. In fact, this particular clip, you cannot see his mouth moving at all.
I mean, this is a treadmill video with a screen grab at 16:28:32. It shows the defendant's back. He's got his one arm on the treadmill rail, and he's leaning over. You can't see his face, and there's no audio. So the jury can draw its own conclusion, but he could be whispering to him. So I think you just need to say
The state submits.
speaks, or yeah, you can say state submits if you want. But I mean, everything, all of this is that each side submitting or arguing the evidence shows. But
I added the state submits, Judge. Thank you.
that's appropriate.
Next one is 23, and it just might have been the way it was phrased. I think it might have been the state's intent to do otherwise, where they say he puts Corey back on the moving treadmill. The first time you see connection between Mr. Gregor and Corey on the video is right before the first fall. And then after that, Corey's trying to get up on his own. So just make an accidental phrasing of it. My objection to that phrasing is it's misleading.
Judge, after Corey falls the first time, the defendant picks him up and puts him back before he falls the second time, and the way it's phrased on there is set up consistent with how Ms. Lento is going to argue it, and it's the way that we prefer to do it so that she can continue
Are you
talking
showing
about what happens before the second fall.
Are you showing stills when you do this, or are you showing the video?
Stills.
I mean, that's an appropriate argument. There's times it looks like Corey jumps back on the treadmill himself and gets ejected off of it. There's other times that the defendant picks him up, and the jury can make that conclusion itself. Next one.
Judge, I'm going to point to number 28.
Which is what?
It's another treadmill picture, and it's after 6 falls, inviting Corey on the head, defendant is still yelling. It's the same argument that I made for the prior slide, but that is the title.
Judge, just so you're aware, I removed the objectionable comment from the last slide. I do not agree with counsel about this one for the reasons that I put forth on the record, and I could put the state submits in this one as well if Your Honor would like.
That's legitimate. That's fine.
Thank you.
Next one.
Moving on to page 40, it says the state's case, and it's captioning defense witnesses. I mean, obviously the state would be free to comment on testimony, but the representation that the state somehow called the witness, that's how I read it, and that would be my objection.
Defense witnesses.
I put the words defense witnesses above them to make it clear.
And Judge, just for efficiency,
And also,
Play a role in the state's case
Sergeant
as
Coles
well.
also was called as a defense witness. So you should make that correction. Just add
Putting
that.
the word both in parentheses under Sergeant Coles.
thank you. And just for efficiency, Judge, it's the same slide on 127, so it would be the exact same argument that I would make.
All right, can you go back to the slide that says defendant kept Corey out of school on March 26th?
Yes, Judge. Hold on one second. Yes, Your Honor.
We know defendant has already abused Corey on March 20th. that runs the risk you're implying knowledge outside the evidence. Prosecutor can't imply you have some other knowledge. Change that. Yeah, I was going to say the evidence shows, or the state submits, the evidence shows defendant already abused Corey on March 20th. Or some words to that effect.
That's fine. I say the evidence shows.
Just avoid using we know.
Yeah.
All right, any other ones from the defense?
There's 153, Judge, where it's.
What is it?
153, it was the original 53. Dr. Deacon corroborated. That's how it starts.
Right, there's actually most of those are all like that. Dr. Deacon corroborated, Dr. Uncorroborated. So you're making an argument that their testimony corroborated it. Is that right, Ms. Fromm?
Yes, Your Honor, that's correct.
I mean, the entire slide read in context show that the state's making an argument that the testimony of those witnesses corroborates the state's allegations.
Yes, Judge, it doesn't say Dr. Deacon said that Corey was murdered. Obviously, she didn't see Corey after.
You probably.
Testimony.
I think you should just add him. The evidence shows Dr. Deacon's testimony. It's always safe to say the evidence shows.
I changed it to Dr. Deacon's testimony corroborated evidence that Corey was murdered.
Ms. Ferranti, anything else?
That would be acceptable.
Okay.
I have more, I just didn't want
I didn't understand your response, so go ahead. If you have more, go ahead.
Page 66, specifically second to last line, the only person that has abused Corey is defendant. Now, Your Honor had made a number of rulings prior to trial, which we all abided by, but I do think that's misrepresentative of information that was not put before the jury and they shouldn't be aware of. But it indicates, obviously, the people's theory, but this idea of ongoing abuse by others is also something that I think all counsels are very much aware of as having been.
You got to show me a slide first. I'm having a hard time flipping through these pages
This
here.
one, Your Honor.
It says treadmill. We're talking about the treadmill video, Judge.
And Judge, there was a lot of comment in closing by defense counsel about this big happy family, which was not the case at all based upon all the information we kept out. Based upon the evidence in the case, that's what the state's arguing. And the state took it to be the same, which is why we didn't object to Mr. Gucci when he said it.
The objectionable line is the only person that has abused Corey as defendant?
Yes, because while that is the state's theory for the purposes of this trial, there's clearly other DCP&P investigations on other people that were not relevant to the trial, and there was a preliminary ruling about it. So I just think
It's an appropriate comment based upon the evidence in the case.
Judge, 69, that's the same as what we just previously changed the heading.
Right, okay. We changed that. Very good.
Corroborates.
And Judge, I am trying to move along swiftly.
No, it's okay.
There's just a few more.
Go ahead.
109 throws Corey in the back seat, very last line of that slide. I just don't recall testimony to that effect or evidence to that effect.
Well, we have a picture of the back seat of a car with no car seat in it when the defendant's car is recovered, and we see him pulling him out of the back seat at the hospital, so it's a reasonable inference that he threw him in the back seat.
And I don't think it's a reasonable inference, Judge. I think it goes to the sympathy of the jury, and that's why it's there.
I mean, it's arguably like an other bad act because it's a motor vehicle offense not to have a child in a booster seat. You can't see the back of the car at Soch, and when the car's recovered 3 days later in Tennessee, I mean, the child's already deceased, so was the seat taken out by then? So
I wasn't trying to argue about him not putting him in a car seat. The argument is that he puts him in the back seat of a car instead of in an ambulance.
I don't think that's how that reads. If that's the argument, that's not how
The only reason I brought up Alcoa was because it's the back seat. There is no car seat, so
Right.
we have the opportunity to lay him across the seat if he wanted to. That's not the inference is throws him in the back seat instead of calling an ambulance where a sick, dying child could be properly treated.
well, you can say that. That part's fine, but I don't think you should say threw him in the back seat. You should say take him by took him by car instead of by ambulance, or words to that effect.
We can say that he was in the back seat though, right, Judge?
Yeah, I mean, the video seems to show he's taken out of the back seat.
Okay.
I don't even know where.
Better than the
It's
front
only
seat.
on the bottom.
Just have one moment.
Either arrange for overtime or see if you can stay. At this point, it's 2:30, so with 100, how many slides you have? 160 or something like that?
130, Your Honor.
Judge, final objection would be to 117, and it is the third line down, the one that is indented. She never had a chance to say goodbye. That may be the state's position, but it goes to the sympathy of the jury, not the elements the state needs to prove.
Judge, the reason I put that in is Ms. Micciolo doesn't know which hospital Corey is at, despite trying to find out. And she testified about her calling around and the defendant not providing her with the name. In addition to that, she literally calls, based upon the testimony of Sergeant Coles from the call log, during the moments that Corey dies, and the defendant misses the calls and never tells her anything, and she doesn't find out about his death until she misses her chance to say goodbye, and the police knock on her door around 6 o'clock.
But it's not appropriate to try and elicit sympathy that the mother didn't have a chance to say goodbye. The rest of those things are fine, that she didn't know what hospital was at, he didn't identify the hospital, but you shouldn't, either party having a chance to say goodbye or not having that chance is not relevant evidence under Evidence Rule 401 that has a tendency and reason to prove or disprove any fact of consequence.
I removed it, Your Honor.
Thank you. All right, anything else?
No.
All right, so I anticipate you're probably going to take all afternoon, and we have to make a decision. Do I charge the jury then today? Or do we come back tomorrow to do that? What time do we go to? I don't know if someone may have plans or...
Judge, we would prefer just to get this done today.
Me too,
if that's
sure.
possible. So.
Me too, definitely, yes. All right, let's go get the jury, please. Yeah, question mark about right? On number 8. 2 hours late, question mark?
We added the question mark, Your Honor.
Thank you.
Guy out the Zoom connection just disconnected in the overflow courtroom. Or actually here, apparently.
The judge might know.
You gotta stay there, but it's real. Oh, all right, yeah. Thank you. Tomorrow night. Okay.
One sip.
So the Zoom connection here, we lost the connection to the overflow. I don't know if it's because we have both TVs on the PowerPoint, so we had that earlier, so. The jurors are coming that way, so once we go this way. No, we wanted to play the PowerPoint displays, simulcasting to courtroom 14.
Got it?
Oh, you might watch. Or even tell them. They got a seance going on in here?
Keep the room cooler.
Is anybody, give you guys a couple? Nobody's in? All right, give me an
All right, thank you. You can be seated, everyone. The jury's in the jury room. All right. First, as to the Zoom connection, I'm advised it's back connected now, and the PowerPoints are on both TVs. Secondly, the PowerPoint references aggravated manslaughter and manslaughter. We've never told the jury about that previously. I'm obviously going to say in my final charge, you want me to say something now, just briefly, that in my final charge, I'm also going to instruct you on aggravated manslaughter and reckless manslaughter, so if Ms. Schroen mentions it, that's why.
Do you mention it?
We do.
There's
It's
a couple
the
slides that
slide.
just say what the elements are.
Then please.
All right. And then Ms. Grimaldi, my law clerk, indicated to me that on the way over, some of the jurors are saying it's a long day, they're kind of tired. You know, again, I don't think it's comfortable in the courtroom or in the jury room, but I'd ask if you're going to be long, maybe at some point find a logical time to break, and maybe we don't charge them today if the state goes to about 4:30 or 4 o'clock or something like that. Just something to throw out there, but I don't want to.
Judge, I defer to you. Ms. Leto can have as much time as she needs.
My only point is, if you go till after 4, am I really going to have them stay another hour? At that point, it's not intended to be a marathon for them. So if some of them are saying they're tired, I can ask them at that point if you like. But I just want you to just pass along the information I have, so I can certainly say to them, "How do you feel?" And
Well, Judge, why don't we see how long it goes for and then see how they feel about it, and then we can make that decision.
well, if you do a minute a slide, it's going to be over 2 hours. So that's why.
I don't think the slides are going to be a minute each, though.
Okay.
You know, some of them are pretty quick, so.
All right.
But
All right. Anything else before we bring the jury out?
knock.
They're going to knock. Okay. Good. Yeah, I mean, at the absolute latest. All right, so Sergeant Dugan also relayed to me, one of the jurors indicated they have a personal obligation in the southern part of the county about 5:15.
6:15, Your Honor.
I'm sorry, 6:15, but based upon the location, I think they need to be out of here by 5 or 5:15 the latest to get there. So, can be guided by that as well. But we'll see how long the state goes.
That's fine.
Yeah, go ahead.
Good? Oh, there's even a line. I forget that there's only one bathroom in here. All right, very well.
appropriate for me to make sure you get both summations on the same day. So I don't want to stop early, but at this point, since it's already 20 to 3, we'll see when the state finishes, and I think it's becoming more and more likely I'll end up giving you the jury charge tomorrow, unless the state's very quick. But obviously, the state has the ability to go long or short, depending. And if it is long, if it's like a 2-hour summation, then we're going to take a break in the middle somewhere. So I asked Ms. Strone to pick a appropriate time. She thinks it's going to go very long. I'm going to give you my final charge after the summations, whether that's today or tomorrow. And one of the things I've done is I've already shared it with the attorneys, so they know what I'm going to charge. So on count 2, murder, I'm also going to charge the lesser included offenses of aggravated manslaughter and reckless manslaughter. I'm telling you that now because Ms. Strome may comment, or Ms. Lento may comment on those 2 lesser included charges at the time of the state summation. So I just want you to know that in advance, and I'll give you all the elements of those, and I'll explain all those to you in my final charge, but I want you to be surprised if you hear about it from the state. Anything further from counsel?
No, Judge, thank you.
Thank you. And it's Ms. Lento, correct?
Yes, thank you,
Ms.
Judge.
Lento, please proceed.
Okay. Good afternoon, ladies and gentlemen. Corey Travis Micciolo loved the solar system, and this case is about Corey. This case is about punishment. On March 20th of 2021, Corey's mother brought Corey home 2 hours late. Corey was punished. He was put on a treadmill. We have a video of this treadmill. On April 2nd of 2021, Corey was brought home 14 hours late. Corey was punished. The person who loved him the most inflicted blunt force trauma, which is child abuse. His heart was lacerated. His liver was lacerated. This case is about punishment. I first want to go over some of the arguments that the defense made, specifically the defense attorney, in his closing argument. The defense attorney argues that Corey died of natural causes. And he's arguing that Brianna's conduct is a ruse to get custody. This argument makes no sense, ladies and gentlemen, right? This was not a ruse that somehow Brianna is making up bruising and taking Corey to the doctor regarding bruising. There's a video that you have seen where you could see the defendant abusing Corey. The defense attorney talks a lot about endangering. Well, you as the jurors get to decide whether what's seen on that video constitutes endangering. And I'm going to talk about this more later, but in terms of the endangering statute and what the state has to prove, the state is not required to even prove physical injury regarding the endangering charge. However, there is evidence of injury to Corey's head, and you hear that from Dr. Andrew when he talks about the contusions that are found underneath the scalp. Defense attorney speaks about substance abuse. Corey did not die because he ingested drugs. There's no evidence of that. So what is the purpose then regarding talking about this? The purpose is to lead you on a path away from the facts of the case and the evidence which is in this case. And the text messages in which the defense counsel is referring to, at the end of it, Brianna talks about the defendant and what's going on with him. This is what is stressing her out. The GoFundMe, right? There's testimony about this. This went for funeral and burial costs for donations. This 33-second video. In the video, you can hear Brianna sighing in response because she thinks that the defendant is not at home because when she gets there, his car isn't there. Brianna lives in Englishtown, not Jamesburg. When Corey gets off the treadmill, he staggers. And Dr. Deacon had more things available to her than Brianna's words. And again, this goes back to the ruse, right? How could this be a ruse? What happened on the treadmill happened before this. Corey was a patient before with this doctor, and there was also testimony that she had spoken with DCPMP. Kim Peace's letter was from the beginning of the school year. The Key West vacation, which is referred to, there was nothing stopping the defendant from going to Key West. And again, we're going to talk about what is required for murder, and there is no premeditation required. So what does that make a difference? The garbage, right? State's not arguing that he was trying to cover up things. It basically tells you a timeline of what happened that day, and that's why the garbage was delayed. Nurse Doyle testified that he did not realize the seriousness of Corey's condition because of how the defendant presented it. The critique of the medical staff at Southern Ocean Medical Center had nothing to do with Corey's death. So why are we commenting on it? The CPR was started and stopped. It was not continuous CPR for 49 minutes. Carnival, the nurse, testified about this, right? Because what happened was Corey had lost his pulse, right? And then he regained it because they were taking him to the CT scan. So it was not continuous 49 minutes of CPR. The blunt force trauma injury, right, a strike or a hit, that's blunt force trauma, may have not left a visible bruise, right? This is what Dr. Andrew was talking about, right? It may not have left a visible bruise, or the bruise may have not come out, or it may have been bruises that were underneath the surface, right? So those are all of the different things as to why what would be there and what wouldn't. So I believe defense counsel said in his summation that the state was saying that all the bruising was specifically underneath. And that was a testimony about that. Sergeant Studdy attended the autopsy and spoke about it. And Dr. Agasa never determined that the death was natural. This treadmill video, which was recovered by the prosecutor's office, speaks for itself. Everything that you need and want to know is captured on this video. The judge at the end of the case is going to talk to you about the law and is going to charge you about the elements, right? The judge is going to tell you that you can use this video as a specific kind of evidence, right? You can use this video to show or to consider what the defendant's motive was, what his intent was, that what happened on April 2nd wasn't an accident or mistake, right? So that's how these two things correlate. The state is not saying that Corey died as a result of the treadmill. What we're saying is what happened in the treadmill shows the defendant's motive and his intent to what he did on April 2nd. And the judge is going to instruct you as to that type of evidence. The treadmill, right? March 20th, 2021. We know that on that particular day that the defendant is angry. He is angry at Brianna and he is angry at the situation. How do we know this? Because he says so. We have the text messages. We know that his purpose and his intent that day was to punish Corey. You can see the text messages, right? of what he specifically says. And if you look at the time, that is right while this is happening with the treadmill. You're almost 2 hours late, what the bleep, and then it continues. And the last text message, this is beyond pissing me off. My entire plans for today are ruined. We know that it was his intent to punish. If you look to the treadmill footage or the videos, there was a few of them. The defendant tells Brianna, I'm at the clubhouse gym. Just drop him off here. He's not at the clubhouse gym, right? This is a clip from the first video, and you can see in there that the defendant is actually walking to the clubhouse gym, right? So what does this show us? It tells us that the defendant wasn't merely working out at the gym and trying to have a nice workout with his son. It shows us that it was his specific intent to punish him that day. Bring him right to the gym. When, it's a clip from the other video, when they start entering the gym area, you can see that the defendant doesn't greet Corey, he doesn't look at Corey, he doesn't talk to Corey. He's going to punish him. He sends Corey straight to the treadmill, right? This is not, I'm working out, let's get together, let's get in shape, let's run on this treadmill. Corey knows how to turn on the treadmill by himself. What does that say? Brianna, Corey's mother, is 2 hours late and dropping him off. In the second video of the treadmill, you can see this, and this is a clip. What is the defendant holding up? He's holding up the number 2. And why? Because he's making sure that Corey knows why this is happening. You're being punished 2 hours late. That's why there's a number 2. You can see that during this video, the defendant is upset, he is angry, he is pacing, he is clenching his fists, as you can see there. Corey's on the treadmill, he's clenching his fists. The defendant is sweating, not because of a workout, because he is enraged about the situation, and he's taking this out on Corey. The treadmill, ladies and gentlemen, is the defendant's mechanism for abuse. And you can see this. He invades Corey's space, and he goes right up to him to intimidate him. Corey knows how to operate the treadmill. He does not need someone to operate it. Corey runs on this treadmill for 10 minutes before the defendant then increases the speed, and then he also increases the incline as well. You can see here in this video, or a clip of the video I should say, that the incline is increased on the treadmill, not just the speed. If you look at one picture, you can see the front is down, and the second picture, it's raised. Corey falls 6 times on that treadmill. Right before his first fall, the defendant knows it's coming. He actually stands behind the treadmill, his hands on his hips, waiting for Corey to fall. And why? Because he's increased the speed in the incline. Corey falls off the treadmill the first time. Corey is airborne. The defendant lets Corey fall. The defendant actually makes room for him to fall. The defendant doesn't stop. He doesn't check on Corey. He doesn't do any of these things. And you can see when this is stopped of the impact of what is happening to Corey right there. The defendant forces Corey back on a moving treadmill. And the defendant then picks up Corey by the front of his shirt and Corey's feet are now dangling. And you can see that right there. And again, as this continues, he's picking him up by the top of his shoulders and shirt, and you can see Corey's legs that he does not want to get back on that treadmill. He treats him like a rag doll, right? He's picking him up, his legs are swinging. And if you look at the defendant's face in this clip, he's like smiling and smirking because he's abusing him. This is what the defendant does while he's trying to put Corey on a moving treadmill. You can see where his mouth is. The defendant bites Corey's head. You can see here that the defendant's mouth is wide open, and then you could actually see how he continues to push down with a bite on Corey's head, and Corey's legs now are starting to go get pushed down as compared to the first picture because they can't keep up. What kind of father would do this to their son? We know, and the injury here, because of this bite, is talked about. Dr. Andrew talks about the fact that there are contusions on the top of Corey's head, but underneath the scalp. After getting Corey back on the moving treadmill, the state submits that the defendant then continues to yell at him. Corey falls off the treadmill a second time. Corey looks up at the defendant after he falls the second time, and the defendant does not stop. Corey falls off the treadmill a third time now. You can see here that Corey is completely flat. He's on his face on the treadmill while the defendant stands by with his hand on his hip. Corey looks up at the defendant, and the defendant still, at this point, does not stop the treadmill. Corey falls off the treadmill for the fourth time. Corey is looking up at the defendant, his father, and his father stares back at him. Still not done yet. Corey falls off the treadmill fifth time. His father has no regard for him whatsoever. Corey falls off the treadmill sixth time. Corey tries to balance on the side of the treadmill while it's moving. And you can actually see in this picture that Corey is more afraid of his father than getting back onto that machine. After 6 falls and biting Corey on the head, the state submits that the defendant is still yelling at Corey. After 6 falls on the moving treadmill, the defendant does not check on Corey, or we can see here, he doesn't even hold the door for him when they're leaving. Before this, you can see in the video that when Corey gets off of the treadmill, he wobbles. The defendant continues to mistreat Corey even when leaving the clubhouse. Corey is 6 years old, and you can see where the arrow is, right? He's at the door at this point. What does the defendant do? He turns his back and just continues to walk in the street. Corey just fell 6 times. He's going into a street. He's 6 years old. Is he holding his hand? No. Is he checking on him? No. Is he doing anything to make sure that that little boy is okay? Absolutely not. On March 21st, the next day, defendant's parents see the bruise on Corey's forehead, and this is from the treadmill. Corey tells David Gregor that he fell on the treadmill during a family discussion. On March 22nd, one of Corey's teachers noticed that the bruising was there and sent Corey to the school nurse. His teacher was actually off that day, Kim Peace. She then returns to school on the 23rd. Kim Peace, the teacher who was with Corey every single day of his life while he's in school, observes this injury. And she describes it as, I saw kind of like a burn, not a burn, but it looked like kind of a rug burn on his forehead. Yeah, because he fell off a treadmill. Kim Peace speaks to Corey about this and the injury, and she describes that Corey was quiet and gives one-word responses. Kim Peace is concerned about this, and she speaks to her coworkers about what she saw. On March 23rd, Brianna sees Corey during her visitation at the defendant's apartment in Barnegat, and Brianna sees Corey, and she also sees this bruise on his forehead, and she describes it as being very odd-shaped, and it kind of looked like an imprint of something. Yeah, because it's a treadmill. She also says that he had a bruise on his chest, and it looked like a scrape. She talks about Corey seeming upset and scared. For your consideration, ladies and gentlemen, which is count 1 in the indictment, is endangering the welfare of a child, right, for abuse and neglect. There is no question whatsoever that the defendant is guilty of abuse and neglect of Corey. What do you have to consider for this charge? Number 1, that Corey was a child. He was. Number 2, that the defendant knowingly caused the child harm that would make the child an abused or neglected child. The defendant knew that such conduct would cause the child harm that would make the child an abused or neglected, and that the defendant had a legal duty for the care of the child. Well, it's his father, so he has a legal duty. He knew what he was doing, right, when he put him on the treadmill and punished him. And the judge, during the charge, is going to talk about all these different things which could constitute child endangerment, right? We don't have to prove all of them. We only have to prove one of them. And the state does not have to actually prove a physical injury. Only risk of a physical injury is enough. The infliction of mental suffering or pain, that is enough. One of the sections talks about exposing a child to unnecessary hardship, fatigue, mental or physical strain that may tend to injure the health or physical or moral well-being of that child. And you are going to see when the judge charges you with the law of how many sections of this could apply based upon what is in that video. Not only did the defendant abuse Corey on March 20th, the defendant knowingly inflicted serious bodily injury that ended Corey's life on April 2nd. And ladies and gentlemen, when you have a criminal case, it is like building blocks, right? That's what you do. Each witness testifies, and each witness corroborates one another. And that is how you get to guilty. And there were many witnesses that testified in this case, and each witness testified to a particular part of the case. And when they corroborate each other, and all the evidence that comes into the courtroom from the witness stands, that's how we get to guilty. The video is evidence, and Judge Ryan is going to tell you this, of the defendant's motive, his intent, and or absence of mistake on April 2nd, right? His motive is to punish because he is angry at Corey's mother. His intent to commit child abuse, to knowingly and purposely inflict serious bodily injury, right, which is the blunt force trauma injuries, which results in Corey's death. Corey to die of football injuries or from a football, right? This isn't a mistake. It's not pneumonia. The defendant lacerated Corey's heart, lacerated his liver, and Corey's lungs were bruised. This is why Corey died. Purpose and knowledge, right? These are states of mind. And the judge is going to tell you when he charges you, well, what is that, right? Someone's purpose or their knowledge. This is a condition of a mind. And you're going to hear that this can seldom be seen from a witness, right? The state's never going to be able to put on a witness to say, oh, this is what's in the defendant's mind. So what do you have to do as jurors? You have to make inferences, right, from the conduct. What did the defendant do? What were his words? How did he act? You have to look at the surrounding circumstances. And you have to infer this. And all of the defendant's words and all of his actions show that the defendant knowingly or purposely ended his son's life. Defendant kept Corey out of school on March 26th. Why? Because he was trying to hide Corey. He was trying to hide these bruises, which the state is not saying that the bruises are the cause of his death. It's the blunt force trauma. But what is happening with the bruises is that this is what everybody is seeing. This is what everybody is noticing. This is the catalyst of how we get there. The defendant on his phone searches on the 25th, will red marks turn into bruises? The defendant kept Corey home from school on March 26th, the next day. The defendant did not verify Corey's absence that day. And that is the day that Brianna contacts DCP&P, not the 28th, on the 26th. And this is important because this is when this all starts unraveling for the defendant. And why? Because Corey comes into school and he has a bruise. And now the teachers know. So what does he do? Takes him out of school. Football did not abuse Corey, okay? Corey goes to football tryouts on Saturday, March 27th. Brianna is present. Corey is not injured, right? This is 6-year-old flag football. And after this, Brianna then takes Corey for a visitation at her house until Sunday, March 28th. Ladies and gentlemen, and anybody in this world knows that kids get bruises, right? They can be playing and they get a bruise, right? Children get bruises. This is not the state's argument. Again, bruises are the catalyst. But what they do tell you is what Corey is not telling you. They're telling you what Corey is too afraid to say. Defendant continues hiding Corey by making him a virtual student. On Sunday, March 28th, Brianna sees bruising on Corey, right? And this is because she has him this weekend for part of the time because she takes him home after the flag football. And she sees that he has a large bruise on his chest, and it looked like fingerprint bruises all over his arms and legs. And then she talks about something else on the side of his hip. And when she brings back Corey from visitation, she goes to the Barnegat Township Police Department, right? And we had that testimony of the 2 police officers who came. Then the police do a welfare check at the defendant's apartment. The police see the bruises, and the police talk to Corey, but they don't separate Corey from his father. They call DCP&P. Interesting, though, is while the police are at the house, the defendant doesn't say anything to them about Corey being quarantined or Corey being exposed to COVID. After the police are at his house, the defendant sends this class dojo message to the teacher, Kim Peace. And what he says is, Corey's other side of the family had left the state and saw him this weekend after being at a mass gathering. Brianna learns that Corey is kept out of school. She confronts the defendant about this, and the defendant blocks her on the phone. There was testimony. Corey was not exposed to anyone with COVID, and no one attended a mass gathering or funeral that weekend because the defendant is trying to hide Corey. All this is going on. He tries to do this while it's virtual, but the teacher is still able to see bruises when he's a virtual student. Corey attends school virtually now this week. Kim Peace, his teacher, says she sees bruises on his cheek, and these are not the same ones as March 23rd. Kim Peace talks to the DCP&P worker, and Kim Peace voices her concerns about what is going on. Tuesday, March 30th, Corey is now attending school virtually. Kim Peace says there's still bruising. She speaks to another DCP&P worker, and she says, I don't feel good about what I was seeing and what I was hearing. She's with Corey all the time. Brianna contacts Corey's pediatrician for an emergency appointment to address her concerns on bruising, and she does this on March 30th because all of this is unraveling. And she also speaks to DCP&P about this appointment she's making because she is concerned. March 31st, Corey again attends school virtually. Kim Peace sees the bruising. Brianna files an emergent application for custody because, as she says, she is now in fear of Corey's life. Brianna acts on her concerns, Corey's mother, on Thursday, April 1st of 2021. Brianna picks Corey up about 4:30 and takes him to Dr. Deacon, who is Corey's pediatrician. She then takes Corey to Community Medical Center, and then she then takes Corey to Jersey Shore University Medical Center. Dr. Deacon's testimony corroborates evidence that Corey was murdered, okay? Corey is examined 24 hours before he dies. Dr. Deacon sees 14 areas of bruising and lesions. Corey has no fever. Corey is breathing fine. Corey has no symptoms of pneumonia. Dr. Deacon calls DCP&P. Dr. Deacon calls the emergency room at Community Medical Center so Corey can have blood work. Dr. Deacon did not think it was safe for Corey to go home. That's why she's calling the hospital. Corey tells Dr. Deacon that the injuries are from football and from falling off a treadmill, right? And again, ladies and gentlemen, maybe some of the bruising was sustained of a kid just playing. But we will say that if they are sustained when the defendant is playing football with him, still under his care. Defendant cancels this CPC evaluation because he does not want a specialist to evaluate Corey. Corey had a CPC, right? And there was testimony about this from Child Protective Services and through a witness. that had this evaluation on April 2nd, and that the defendant canceled this appointment, and that he would not let Brianna take Corey to the specialist without him. And we know that the defendant received an email with a court order at 4:43 allowing another 7 days for this CPC evaluation. And you can see right here in these text messages where the defendant texts Mark, who had been identified as a DCP&P worker, and he says there, hey, I can't get off work tomorrow. I just asked my manager, so I can go next week. Just let me know the number to schedule. Right? So here, he can't get off work. But if you look at the next text message, hey, so I'm going to take off work tomorrow because Corey's mom decided not to bring him back from visitation, and I'm going to have to go to court tomorrow morning since Natalie isn't working, and who do I reach out to? The defendant can take off work. He can't take off work to have Corey evaluated by a specialist, but he can take off work when he wants to file against Brianna. Because the defendant doesn't care about Corey. He doesn't care about his health. He doesn't care about his safety. He doesn't care about any of those things. The only person he cares about is himself. On 4/1, this court order comes out, and Brianna actually receives the family court order between the time when she was at the pediatrician until she's on her way to community medical center. And there was testimony about this, about what this court order said. And in this court order, it says the court reviewed the letter of investigatory findings, right? And Brianna's request for custody was denied. But it did say that there had to be a CPC evaluation agreed upon by both parties, right? Because at this time, they're both custodial parents of Corey, and there also had to be a pediatrician appointment within 7 days. But Brianna had already taken Corey to the pediatrician, and she had already spoken to DCP&P about this. But what's really interesting about this is that the court did not have the video. The court only reviewed a letter. And Brianna did not receive custody. Corey is taken to community medical center. This is on the advice of Dr. Deacon. Brianna brings Corey to the hospital. Brianna's visitation is almost over when she receives this court order where she's not going to be granted sole custody. Corey is examined. He is absolutely fine. Corey does not have pneumonia. Brianna is given the option to drive Corey and to sign this release. It's noted in the records, and there was testimony about this, that Brianna had to bring Corey home. And she has to bring him home because this court order came out and she was denied her request for custody. Defendant does not want a doctor to examine Corey on April 1st because he does not want Corey talking to doctors without him because he is afraid that Corey is going to tell. And this is what this is all about. The defendant on April 1st, you can see this, exerts pressure on Brianna to leave the hospital, and that is because he does not want Corey to be evaluated. He calls the hospital, he calls police departments, he goes to the Barnegat Police Department. The following morning, he accuses Brianna of kidnapping. The defendant pretends he is clueless as to Corey's mother's whereabouts, but meanwhile, he talks to her. There is a text from the defendant to Brianna at 7:26 on 4/1 while Brianna is at the hospital, right? And before Brianna's visitation time hasn't even ended, right, because she has till 7:30. This is at 7:26. Where are you? It'll be past 7:30 and I will take over and be with my son. I have no idea where you are. She tells him, I'm driving to Jersey Shore Medical Center. I'm doing what a caseworker for DCP&P told me to do. The defendant and Brianna speak that night on the telephone, right? The defendant calls Brianna at 7:27, and we know all this, right, through Sergeant Coles, because we have all this information from these phones, and we have the call logs. Defendant calls Brianna at 7:27. There's a 37-second conversation. In the meantime, around 8 o'clock, Brianna now is at Jersey Shore University Medical Center. The defendant called Brianna at 8:42, and there was a 1 minute and 12-second conversation. Brianna talked about this in her testimony. She testified about this conversation. She says that the defendant argued with her about being at the hospital and that he wanted her to leave the hospital with Corey. Then after that, what happens is her phone dies for a short period. They were in contact the entire night except for this short time when her phone dies. In response to this, and this says everything, what does the defendant do? He searches Neptune police number at 8:43. He searches the Jersey Shore hospital. He calls Jersey Shore at 8:43, has a 38-second conversation. He calls the hospital at 8:44, has a 5-minute and 36-minute conversation. Calls the Neptune police, right? Because that's where the hospital is located, so he's calling the police over there too. 10-minute and 14-second conversation. He calls Jersey Shore, talks to the hospital for 12 minutes. Then he texts this girl, Marcy, who we met on the internet, who we actually never met in person at this point, and says, at police station now, and we have that text message. Why? Because he goes to the Barnegat Police Department. He calls the Barnegat Police Department. He texts Laura, who we heard testimony is now his girlfriend, and she says to Laura, this other girl, 2 hours late, and she's not responding. Oh, really? Because there's text messages, and you just talked on the phone. Defendant calls Neptune, 7-minute and 12-second conversation. The defendant speaks to the DCPMP worker, 1 minute and 18 seconds. He texts another girl named Amy, 10-minute at 10:17. The defendant calls the Stafford Police Department at 10:51, and there's a 6-minute and 8-second conversation. Why is the defendant doing this? Because he is afraid that Corey is going to tell. He is afraid of what the doctors are going to see. The defendant knows where Corey is and why. Brianna tells him. The defendant tells others. There's a text message that defendant texts Marcy at 7:48, and where he says to her, she has him at the hospital getting blood work, not going to be back for a while. The defendant speaks to Mark from DCPMP numerous times, 4:26, 5:26, 7:24, and 10:06 p.m. The defendant spoke to the correct hospital where Corey and Brianna are, and the defendant spoke to the police department where the hospital is located, because he knows exactly where she is. Defendant deflects, and he gaslights Brianna. This is what he does. And he tries to discredit her, manipulating people and the situation, because he does not want anyone to see the real Christopher Gregor. The only person that has abused Corey is his father. And we know this because it's captured on a treadmill video. Defendant is not worried about Corey being with Brianna, right? The defendant doesn't care about Corey's health. He doesn't care about his safety. The defendant cares about preventing Corey from disclosing. That night, when the defendant realized that he could not stop Brianna from leaving the hospital, he could not stop him from being evaluated, what does he do? He doesn't wait up for Corey to come home. Doesn't care. I mean, your son is being evaluated at the hospital, right? If you really cared, you would have stayed up to see what's happening. But he doesn't do that. He goes to sleep. He then starts the next day filing his emergency application. Why? Because he's got to get in front of this. Because he doesn't know what Corey said. The defendant does not care about Corey. He cares about controlling the narrative. At 11:43, the defendant says, "Why are you ignoring me?" to Brianna. And she explains to him, and this is later that night on the 1st, "My phone died and I just got a charger. I am at the hospital because DCPMP spoke to doctors and they told me to come here. You could have come here from the beginning. You said, no, drop him off. We could have taken turns the whole time. I'm not doing anything wrong. Stay up and I'll drop him off soon as we're done." She writes, "You're not going to stay awake." At 12:48 a.m., she writes, "How are you going to go to court and say anything about me keeping him? You won't even stay up for me to drop him off. I'm offering right now." The defendant just doesn't respond. The next message is not until 6 a.m. the next day. Brianna had to take Corey back because she has to comply with the court order. The state submits that Dr. Ong corroborates evidence that Corey was murdered. Dr. Ong is a pediatric emergency room doctor at Jersey Shore. He sees Corey less than 24 hours before Corey dies. Corey is admitted to the emergency room, not the hospital, just the emergency room at 9 p.m. Corey was afraid to answer Dr. Ong's questions. He is described as scared. He does a head-to-toe examination. His chest exam is normal. He is not in respiratory distress. He is not wheezing. There's no murmurs. There's no hypoxia. There is absolutely nothing wrong with Corey. His lungs were clear. The doctor maps all of these bruises, and he describes bruises and abrasions and bleeding under the skin. Corey is examined 3 times before he leaves Jersey Shore. There is a skeletal survey that is done, and the doctor explained this. There's 19 radiographs, right? What are these? These are x-rays. Corey gets a chest x-ray done that night, and the doctor tells you that there's no infiltration noted in his lungs, right? So Dr. Ong is not just taking Corey's word for it or his mother's word for it. He orders these tests. He also speaks to DCPMP, and Corey is released home with his mother a little after 1 a.m. on 4/2. The discharge instructions from Dr. Ong, and he testified about this, is that Corey was supposed to follow up with a child abuse specialist who was not at the hospital that night. And why? Because it was Easter weekend and he wasn't available. His oxygen and blood pressure were normal. He was negative for SARS. He was negative for COVID. You know, the reason he was kept out of school for virtual. He was negative for flu A, B, and RSV. Dr. Ong did not see the bruise chart, right, which was done by the pediatrician. This is his own assessment as to what he saw. And there's no sign of infection, because what Dr. Ong does is he also orders his own blood work or lab work. And Corey's white blood cell count is not elevated whatsoever. And there's absolutely no sign of infection. The evidence shows that there was nothing wrong with Corey when he was returned to the defendant at 9 a.m. on April 2nd, 8 hours before he died. Corey was released after 1 a.m. from the hospital. Brianna drove from Neptune to Englishtown after the defendant did not respond to her that night. Brianna and Corey slept together in the basement. Brianna was with Corey. There was no evidence that Corey had a fever, was sick, or injured other than the bruising. What do we know? We know that morning that he ate breakfast. We know that Corey played on Brianna's phone during the car ride. We know that Corey was talking without coughing or straining, right? This accidental recording, right, that happened is right then, in the morning when Brianna is dropping off Corey. And the defense attorney in his argument is making this argument that there's a noise heard. What you hear is Brianna sighing because she thinks that the defendant isn't home because she doesn't see his car. We know that Corey was able to walk and also climb the stairs to get into that apartment. There was nothing wrong with Corey. The defendant inflicted serious bodily injury resulting in his death, and it was blunt force trauma. This is the defendant's final act of child abuse on April 2nd between 9 a.m. and 1:03 p.m. The defendant was the only person who was with his son when these injuries were inflicted. Corey did not die of an infection. He died as a result of this trauma. His heart was lacerated, his liver was lacerated, his liver was bruised, and also his lung was bruised as well. When Corey was brought to the hospital, right, his body is already shutting down due to the blunt force trauma. This is what results in cardiac arrest, seizure, then death. Corey died of blunt impact injury of the chest with laceration of the heart, contusion of the left lung, a laceration and contusion of the liver, and this was a traumatic cause. And that was the testimony of the forensic pathologist, right? Dr. Andrews' testimony proves that the defendant murdered his son Corey. The cause of the death, as per the pathologist, was a lethal train of events, and without which death would not have occurred. Meaning, like, there's no natural cause for this death. He didn't inflict it upon himself. It's blunt force trauma. It's a strike, a hit. That's what blunt force trauma is. He also talks about the pattern, distribution, and varying ages of bruises indicative of child mistreatment. And Corey had contusions over a wide area of his body of varying ages, from under his chin, his head, his trunk, his extremities. And this is where we get back to this bruising again. It's not that a kid has a bruise, so all of a sudden, it's child abuse. That's not what anyone is saying. It is the pattern of bruising. It is the amount of bruising. It is where the bruises are located. And this is what Dr. Andrew is talking about. He observes deep contusions that did not correlate with contusions on the skin, right? So that would be contusions underneath your skin. And he was able to see this in the slides and with the autopsy photos. The bruise near Corey's shoulder blade is not typical from a child running and playing. The bruise on Corey's chest was in a very odd place, unless there was a good explanation for it, right? The doctor talks about Corey's cause and manner of death. Dr. Ragasa performed the autopsy on April 3rd of 2021. Dr. Ragasa concluded that the death was undetermined. He did not conclude that this was from natural causes. The state sought the opinion of Dr. Andrew in February of 2022. And it's not to say that Dr. Ragasa's autopsy, right, what he did in the autopsy is the issue, but is the interpretation of his findings. Dr. Andrew is a former pediatrician, and he's also a forensic pathologist, right? And the defendant is now placed under arrest on March 9th of 2022. Then Dr. Ragasa amends his report in August of 2022. this case was also reviewed by Dr. Falzone, who is the chief medical examiner for New Jersey prior to this being amended. And yes, ladies and gentlemen, the prosecutor's office contacted the doctor. There is a 6-year-old who has passed away, and Dr. Ragasa, in the report which was testified to, talks about a laceration to this child's heart. And yes, we wanted to see what happened to the 6-year-old. Dr. Andrew talks about Corey's lungs. There is a large left lung contusion, and this is not pneumonia. So there was some testimony about this the other day that there was noted in the autopsy report that there was just congestion in the lungs. Dr. Andrews tells you that this is a lung contusion. It's a lung bruise. He also talks about post-mortem CT scans and how they are not reliable. Here, this was read by a clinical radiologist at the hospital, and he tells you that it takes special training to interpret the results of post-mortem CTs because they don't look the same in dead people as they do in living people. It's not that radiologists can interpret CT scans, it's that it's a post-mortem scan. Dr. Andrew talks about Corey's heart and the injury. He tells us that he had a visible contusion on the outside of the heart. The internal examination of Corey's heart shows a laceration or tear in the tissue near the apex of the heart on the inside wall of the heart, right? So what does that mean? This injury was located in the inside of Corey's heart, right? It has to get cut open the heart to even find this injury. It's inside. And he talks about this being a tear of partial thickness, right? So what did he say during his testimony? This tear or this laceration, it didn't pierce all the way through the heart. That's why he's saying that Corey did not die immediately, right? Because it's not a hole. And he also tells us that the laceration and tear, it's not a matter of size, it's a matter of where that is located and what it's doing, right? There's one on the left ventricle and lower left chamber of the heart, all right? And Corey's heart could compensate for several hours because it didn't pierce all the way through. And he also told us that Corey did not bleed out from these injuries. And this wasn't an instant death. And he tells us that this is trauma, and what happens is your heart tries to compensate, and then ultimately your heart decompensates, and then what happens is you go into cardiac arrest. And that's why Corey went into cardiac arrest. He also talks about stress cardiomyopathy in Corey's heart. And ladies and gentlemen, what he's saying is that there's this marker that Corey is suffering ongoing stress. Look what's happened to him. Dr. Andrew also talks about Corey's liver. And there's 2 injuries which are located on the liver, right? There's a laceration or tear in the liver tissue on the right edge, the right lateral aspect of the liver, right? And he talks about the photos clearly show that there's also a contusion that goes fairly deeply into the liver tissue itself. And under the microscope, this was not a super fresh injury. So this is not an injury that could be attributed to CPR. Why? It's not a fresh injury. And he describes this as being an ugly injury, but this was not life-threatening. This is not what killed Corey. And he talks about there was a contusion or bleeding underneath the capsule of the liver on the front edge of the liver. So what he's talking about are 2 separate injuries, okay? But Corey's liver is lacerated on his lateral side, the lateral side of the liver. This is not caused by CPR. It's the lateral side of his liver. That's where the laceration is. Dr. Andrew also talks about Corey's scalp. And he says that when looked at the skin underneath the skin, there was a contusion on the top of his head and a couple of contusions on the backside of the scalp that you couldn't see on the surface. And this is what I was referring to before regarding the bite on Corey's head. The injuries and Corey's condition provide the timeline from when the defendant inflicted blunt force trauma injury on his son. Dr. Andrew is able to determine that these blunt force trauma injuries were inflicted on Corey between 9 a.m. and 1. And what he does is he reviews slides, which are tissue samples, right, which they take from the autopsy, and he observes an inflammatory response with the inflammatory cells which are located in Corey's heart and liver. And this inflammatory process involves the appearance of certain repair cells to the area of injury, which results in a predictable time frame. So this is this inflammatory process, and it's a well-established. So the laceration to Corey's heart and liver occurred roughly at the same time, and that's what he says. The injuries that Dr. Andrew notes are more indicative that Corey is struck or hit multiple times than that these injuries were somehow caused by CPR. Dr. Andrew tells us that given the age of these injuries is entirely incompatible with them been produced by CPR because they wouldn't have had this inflammatory response that takes hours to develop, right? And he also talks about CPR on the right side of the chest. CPR is done on the front of the chest. And like I said, the anterior liver injuries are not uncommonly seen with CPR, but not an injury on the side of the liver that goes deep into the tissue. So that's what he's talking about. This lateral injury, which is a deep tissue liver injury, it just simply can't be caused by CPR unless you're doing liver CPR to bring back breathing. In the context of discussing the CPR injury, the doctor tells us that he has never seen a heart or internal laceration of the heart like this in regard to CPR-related injuries, right? So again, it is the fact that this laceration is found deep inside of the heart. And he talks about this inflammation process as well. So the location of the heart and liver injuries are more indicative of the defendant striking Corey more than once, right? And this is something that you have to use your common sense about, right? They're happening at the same time, but it's likely more than one way. Because how is it possible to have an injury to your heart and to your liver on the backside? Certainly not possible to occur with CPR that happens in the middle of your chest. Corey did not have an infection, and we know this from Dr. Feingold. She is a practicing doctor specializing in pediatric infectious disease. She is board certified in her specialty. She actively works in a hospital, a trauma center, and teaches medical students, and she has all the technology available to her. And she reviewed numerous pages of discovery, and she tells us that she didn't see anything that suggested infection. And when asked if her opinion was to a degree of medical certainty, she responded, absolutely. Corey did not have any signs of infection leading up to his death. IV pediatrics, there was no evidence of any kind of infectious process. Community Medical Center, he had no signs of an infection. Jersey Shore, he had a normal white count, no respiratory viral infection, and he had no evidence of having an infection per the doctor. He ate breakfast, he was speaking without coughing, there was no wheezing or shortness of breath, walking and climbing stairs. At Soch, when he arrived, he was not in respiratory distress. There was no retractions, there was no wheezing, no crackles. There was nothing observed to suggest a lung infection. Any shortness of breath was because he was less than 1.5 hours from his death. So this is what the doctor is talking about, not his breathing being off because of some type of infection, but Corey's body was shutting down. He was going to die very, very shortly. She talks about the elevation in white cell count, right? The blood work that was taken at Jersey Shore, there is an elevation in the white blood cells. She's saying, this isn't due to an infection. This is because this is what's happening because he's already suffered blunt force trauma injury. His body is shutting down. Of course your white blood cells are going to be elevated at that point. And she talks about this as a cell count consistent with a giant surge. And she also talks about the other level, which is a stress response. Not an infectious response, but a stress response. And this is also consistent with the elevated glucose levels that were determined in this blood work because his body was shutting down due to the blunt force injury and due to this inflammatory reaction that Dr. Andrew was able to find under the microscope, right? And this is how you know that the injuries were not caused by CPR, right? Because if they were caused by CPR, then that would have been after death. So why would there be any inflammatory process there? It is not caused by CPR. Again, factors that do not support infection. There's no bacteria in Corey's bloodstream, which this factor is not even mentioned by Dr. Bodden in his report. The scan of the lungs is a post-mortem CT scan, right? And Dr. Feingold and Dr. Andrews corroborate each other with their testimony. Post-mortem CT scans are not used in the diagnosis of pneumonia because the lungs are no longer holding air. So it's not that the use of the CT scan is wrong, right? But if you're going to use the CT scan, your lungs have to get filled back up with air for that to be reliable. And that's what Dr. Feingold was talking about. Why? Because you stop breathing when you pass. And the lungs would have to be inflated or insulated for this to be readable and reliable, right? So Dr. Bodden's testimony about, the infectious disease doctor, and she didn't know the availability or whatever it was, that's not the issue. If you're going to use the scan, you have to inflate the lungs back up so the scan is actually reliable. This post-mortem lung swab, this is also something that is relied upon for this idea of sepsis, okay? In this lung swab, what was grown, the staph, is one of the most common bacteria around. And this is from the infectious disease doctor who treats children with this all the time. And this is not a reliable way to diagnose an infection in the living because there is a high risk of frequent contamination. And that could even be for intubation, right? And we know that Corey was intubated, right? And we also know that Corey was at the hospital and everyone was touching him. There was nurses, there was a doctor. His body is transported by a funeral home. The autopsy is done the next day. And she tells us how highly prevalent the finding would be in children, right? We know this about kids. They sneeze, they cough, they have this stuff everywhere. And this is why her testimony is important. and which he tells us is the normal clinical course of this endopneumonia, occurs over the course of days. It doesn't just occur within hours, and it includes a fever, and there's gross abnormalities, which be noted on a chest x-ray, which Corey had, and everything is fine. There would be an abnormal pulmonary exam, and there would be pus, right? And Dr. Bonin said that in his report, there's no indication that there was pus or an abscess on Corey's lungs.
Ms. Lento,
Yeah.
yeah, we've gone about an hour and 10 minutes, ladies
Okay.
and gentlemen. So before Ms. Lento transitions to Dr. Bodden, why don't you take a short break, stretch everyone's legs, give the court reporters a break, and then we'll come back out.
All right.
p.m. The jury's in the jury room. Anything from counsel outside the presence of the jury?
No, Judge, thank
All
you.
right, so let's try and keep it short, and we'll wait for the jury to knock, but hopefully 10 minutes or less. Thank you.
Please exit.
You want me to take this off?
No, leave that. I'll just go down. Here, put the,
We're back on the record. The jury's still in the jury room. Corporal Bennett, did you tell them to knock her?
Yeah, want me to knock? I thought we just gave them a timeline.
Right, why don't you knock and ask them if they're ready, please.
You guys ready?
Okay,
One in the bathroom.
thank you. Perfect, all
All
right.
right.
405.
You're out.
Thank you, ladies and gentlemen. We're going to continue with the state summation.
Thank you, Judge. So in regard to Dr. Auden's testimony, he's not board certified in pediatrics or infectious disease. He's hired by the defense. He did not give an opinion with a medical degree of certainty even. He's talking about percentages of what he thought happened to Corey. And he even gives this kind of strange theory about SIDS, a SIDS theory in an almost 7-year-old child. And Dr. Bauden is basing his entire opinion on a postmortem CT scan, a postmortem lung culture, and Corey's white blood cell count. But again, we talked about this already. This is the blood cell count from when Corey was at Southern Ocean Medical Center, when his already body was depleting from the response and the injuries that he had suffered. Dr. Bauden did not consider the facts which were crucial and essential in determining the matter of death. And the doctor acknowledged this during cross-examination when he says that facts, right, or the details, and I'm summarizing right now, right, that is essential when considering manner of death. And that's why when you look at this opinion, it just doesn't make a whole lot of sense, right? Because it's not congruent with the facts of what's going on in this case, right? Because what's happening is it's an attempt to explain away Corey's injuries, right? Corey presents at the hospital because he has blunt force trauma injuries, right? So let's explain this away by saying it's pneumonia. And now we have to try to explain away what the actual injuries are. Oh, so it's CPR. And the state submits to you that this is why this does not make sense, because it's not based in any fact, right? What is presenting, what is going on with Corey? And that's why none of this was considered, which should be considered when you're determining the matter of death. How somebody died, you're not considering the fact that there were bruises on them. You're not considering any of these things when you're determining a matter of death. It just doesn't make sense. And that's because it's an attempt to explain away the injury. This is what I'm speaking about, right? It just doesn't fit. You're trying to put a square peg in a round hole. And if you look at what was actually happening, right, and Corey's lack of symptoms and all of these lack of things, then we know that Corey did not have an infection, he did not have pneumonia, and he certainly did not have sepsis, especially when there's a blood culture. and there's no bacteria even noted in his blood. The fact that this is not pneumonia, right, this is corroborated, as we already discussed, by Dr. Andrew and Dr. Feingold, and by the direct observations of the people who are actually there, right, who are the nurses at the hospital who actually treat Corey. Dr. Andrew tells us there is zero, not one scintilla of evidence of sepsis or any other infectious disease process. 6-year-olds don't just die. They don't die suddenly out of nowhere. And we know what this is. It's a murder. We know how it happened. Blunt force trauma, strike, a hit. We know who did this. The defendant, Corey's father. We know when it happened. It happened between 9 a.m. and 1 p.m. We know where it happened. It happened at the defendant's apartment and under the defendant's care. And we know why it happened, right? And this is what I was talking about in regard to motive and intent and being able to use the treadmill video from the 20th to determine this, right? The defendant was angry at Corey's mother because she took him to the doctor, she took him to the hospital, and Corey was returned home almost 14 hours later. And the defendant believed that Corey had disclosed this abuse. The defendant caused Corey's death or seriously bodily injury resulting in death. And he did so purposely or knowingly, right? And this is what the state has to prove. Part of it, the judge is going to tell you more in regard to murder, right? You're going to see the state does not have to prove this long plan of premeditation, right? The state has to prove that the defendant caused Corey's death or serious bodily injury that then resulted in death and did so purposely or knowingly, right? And what is purposely? A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. And what is knowingly? A person acts knowingly when the person is aware that it is practically certain that this conduct will cause death or serious bodily injury resulting in death. It is the state's argument that the defendant knowingly inflicted serious bodily injury which resulted in Corey's death. Child abuse. We know that this was the conscious objective of the defendant because look at the injuries, right? Look at the type of injuries. You know what you're doing, and this is purpose, when you inflict these type of injuries that are so critical and so life-ending, and they're inflicted upon a 6-year-old. And where the injuries were located, and we kind of touched on this before, right? You could determine that it was multiple strikes. You could determine that it's one strike. It doesn't matter. It is the type of injury and common sense, right, of what the defendant did. You can also consider aggravated manslaughter, which is a lesser included charge of murder. And in that particular charge, the state would have to prove, and this is only part of it, the judge is going to give you more, that the defendant caused Corey's death, and the defendant did so recklessly. And the defendant did so under circumstances manifesting an extreme indifference to human life. So absolutely he did this, ladies and gentlemen, right? He caused Corey's death. He did so recklessly. And there was an manifest extreme indifference to Corey's life. So course, right, with the type of injuries. The third thing for your consideration, which would be a lesser included, would be for reckless manslaughter. And again, the judge is going to give you the law regarding this. And basically, the state would have to prove that the defendant caused Corey's death, and he did so recklessly. Of course. The state submits that the defendant's conduct was beyond reckless manslaughter. It is beyond aggravated manslaughter. And again, when we're talking about motive and intent, right? On March 20th, Brianna was 2 hours late when she dropped off the defendant, and he was punished on the treadmill. On April 2nd, you know what the defendant's motive, his intent. We know that this wasn't an absence or mistake. Corey was 14 hours late, and his mom had him at the hospital all night. The injuries to Corey, and we talked about this already, were on two separate parts of his body. How he behaved at the hospital and when he fled, the kind of things and the amount of things that he deleted from his phone, his searches, even his garbage pail and his flight, this all shows that he killed Corey. The defendant's actions before and after Corey's death prove murder. The text messages on the morning of April 2nd show that he was angry and trying to get ahead of things because he does not know what happened at the hospital the night before. And he says, I'm going to court because you decided to go when you had 7 days last night, and by your text, you were still there at 12:50 at night. You are a detriment to Corey's health, and I will be going to court today about it. He sends that to Brianna at 6:46 a.m. that morning. By the way, school starts at 8:30, so have him back before 8:30, right? He sends this text to Brianna at 6:46 already that morning on the 2nd. Interesting, there is no school on April 2nd. He sends her a text message that morning on the 2nd at 8:37 in the morning where he says, I mean, considering you did kidnap my son for an entire day and night, the minimum that is happening is an entire day and night is going to be removed from your next visit maximum. Hopefully, the courts will agree with my application this morning and you will lose all rights. Well, I don't see anything in the court orders that we talked about that the defendant gets to be the dictator of custody times and all of these things. But the point of this is that at 8:37 in the morning, he is already fired up about this. The defendant tells people that Corey is fine. 8:56, text to Marcy. He confirms, yeah, Corey's fine after he's dropped off. And then he texts Amy, he's home, but I still applied for an emergent application to remove any visitation moving forward. Right? Good. Did she say why she kept him? Right? This is Amy now. Nope. Really? Because it's not correct. He knew exactly where Brianna was. Then to Amy to the defendant, he's okay, right? Yeah. Certainly not someone who is infected with hyperspeed pneumonia, causing their death. Defendant is furious and argues with Brianna, but does not say that anything is wrong with Corey. There's another text message conversation where she says to him, stop being so cocky. And ultimately, at the end of this conversation, the defendant says, shows how much evidence there is, doesn't it? You going to be in for a rude awakening today. And this shows you exactly what was going on in the defendant's mind. And cell phones today, right? Text message, searches, all of these things. They are screenshots into someone's mind of what they are doing. The defendant's call to the child abuse hotline at 10:04 a.m. proves that the defendant murdered Corey, right? And this is a significant thing, this call, because there is a lot in there, right? Defendant's words and what he really says. In this call, and there was a transcript, he says he's unsure where Brianna lives. Really? He has no idea where she lives? There was thousands of messages between them. He also says that there's no phone number readily available. He's actually actively texting with Brianna when he's making this phone call, and there was testimony that there was about 800 messages between the two of them. It's also confirmed about the worker saying that there had to be 7 days for the evaluation, right? And what's the reality of the evaluation? Well, the defendant had already canceled that, right? And what he says is that Corey's mother was radio silent from 7:30 until 1 a.m. Well, we know that that's not true. We know about the phone call and the text messages. Defendant's call, as we continue, the defendant's words are that Brianna would not leave Corey's side. Yeah. Because she thinks that Corey is being abused. And then he talks about not being there for his son, and he talks about Corey came home and told me, and the fact that he is so worried. And the reason that he wants to be there for his son is not because he cares about Corey, it's because he doesn't want him evaluated and he doesn't want him talking. And this is the most interesting part of this call. And this is what he says. Now, after she had him for an extended period of time yesterday and had him at the hospital and was coaching him to say that I hit him, he said it. So my big concern is just, that her coaching is going to be disregarded, and it's only going to be regarded as him and his statement. So who is he referring to? He's talking about Corey. And what does this show? It shows you that on that morning, the defendant believed that Corey had made a disclosure. But what is even more interesting about it is look at the word he uses. He uses the word hit. Corey never said that he was hit by his father. You heard the pediatrician is that he fell off the treadmill. And this is precisely where the defendant slips up in this call. Because when Corey got home that morning on the 2nd, he inflicted blunt trauma injuries and he hit him. We know what his motivations are. We know what his intent was. Why is he using that word? And this follows with the fact that this is what the defendant does. He diffuses, he deflects, he distracts, right? And he then in this call starts going after Brianna. And why is he doing this, right? We know that he's already abused Corey on this treadmill. Right? You have to keep this in mind. This is all after that. So what is he saying in this call? he's talking about, oh, I'm concerned that she's relapsing and she's erratic and there's no rationale behind it. But then he says, well, there's no specific evidence in that regard. Why? Because he has to place blame on Corey's mother, because this is how he continues to effectuate his abuse. He then begins to attack her family, and then he's talking about coaching. Coached. Know what happened to Corey. This is what he's calling and saying after the treadmill. Corey never disclosed, and I said this before, that he was hit. He said he fell from the treadmill. The defendant is the only person who ever uses the word hit. And that's because he hit. The call to the hotline is evidence of murder, not pneumonia, and sepsis. Corey wasn't sick. There's no report of Corey acting loopy when he got home. There's no report of pneumonia 6 hours before going to the hospital and 7 hours before death. There's a confirmation that there is no suspected COVID, right, on this call. There is a confirmation on this call that there are no respiratory infections, coughs, sore throat, or anything like that. Think about this, ladies and gentlemen, right? If Corey would have been returned sick or injured or any of these things, right, he would have been blowing up this screener and DCP complaining about Corey's mother. He would have been telling anybody who would listen about this. That's because Corey is fine. He would have been texting everybody. He would have been telling everybody this. Defendant's actions after the hotline call until Corey goes to the hospital corroborate that the defendant inflicted fatal injuries to Corey that morning, right? The defendant begins texting with Margie early that morning, and the two have never met in person, but according to the text, the two are going to meet for the first time at the defendant's apartment that night. These texts, what they demonstrate is a total lack of disregard for Corey, right? They demonstrate that Corey does not have a pneumonia because it's the same thing, right? If there would have been anything wrong with Corey, he would have been texting away, oh, she did this, she did that, because Corey is fine. Defendant would not miss an opportunity to blame Corey's mother or complain. Corey is fine. Defendant's actions after the hotline call corroborate, right? Defendant texts Marcy at 11:53, right? Oh, since I took off from work, my son is sleeping, right? The next text, 12 o'clock, nice. I might take a nap so I don't fall asleep at 10 p.m. on you, LOL. 12:14, do you desire a traditional pizza? It's talking about pizza. 12:19, I am actually really excited to see you. 12:23, there's a photo of pizza and there's more talk about pizza. 12:51, you play chess. 1:01, well, just let me know when is the earliest that you can come. 1:46, I'll be able to set it up. I'm super excited after destroying you and party. He's talking about a video game, okay? If Corey was symptomatic and dying of pneumonia, would this be his text messages? Of course not. And I know that is hard to conceive how somebody could act like this, right? But at 2:06 p.m., right, the defendant sends this selfie picture, okay? The defendant is smiling, right? And there's this ordering of McDonald's. And it was most interesting about this picture, Corey does not look good in the picture, but look, ladies and gentlemen, Corey is not wearing a shirt in the picture. Okay? And what does that tell you? He went that day with the clothes his mother sent him in, which was a sweatshirt and jeans and underwear. And Corey's mother identified this underwear, right? And where is that found? It is found in this garbage pail when this was delayered. So we know by this picture, right, what is the significance of this? Corey does not look well. He has a blanket up. All his bruising would be covered, or anything would be covered. But we know that not only was the injury inflicted before 206, but we also know that Corey was having symptoms before 206. The facts of the case corroborate Dr. Andrews' findings. And this is what I was talking about in terms of the layering of this garbage can, right? And you can see that the soiled clothes are in there. Because the murder occurred before 206, right? And Corey is not wearing a shirt, and we know that Brianna had sent him in those clothes, which were clean. The clothes are under the McDonald's bag. That means that the defendant took Corey's dirty clothes off before 2 p.m., and it's consistent with Dr. Andrew. The defendant's actions after his selfie corroborate that the defendant murdered Corey. At 2:06, right? Don't think I'm moving. 2:13, want to talk on the phone? This is after the picture, right? And I understand, ladies and gentlemen, it's hard to fathom that someone could have such a lack of disregard for this child. At 3:08:37, the defendant searches and later deletes loss of consciousness, sleepy, and nauseous. This was at 3:08. The defendant did not delete all of his searches. He deleted specific searches. At 3:22, right, 26 minutes before arriving at the hospital, the defendant sends a text message to Marcy where he says, "I'm so excited, ha ha." Even after the defendant takes Corey to the hospital, he is still texting Marcy about their plans, right? He's texting her the whole time. Because he does not care about Corey. He doesn't care about his health. He doesn't care about anything. And he left that kid while he was there, not checking him, in his apartment, while Corey was passing from the injuries, and then he takes him to the hospital. By 3:08, Corey has lost consciousness, yet he's not brought to the hospital until 3:48. That is the time that he is brought to the hospital. And despite Corey losing consciousness, which is deleted from his phone, the search, he does not call 911. What does that show? This child is in this critical condition, and you don't call 911, and you don't call an ambulance. You know why? Two different things. He didn't want anyone inside his apartment. He just didn't care about Corey. No life-saving measures. He only goes to the hospital after a 13-minute phone call with his mother, right? And this is why he goes to the hospital. He goes to the hospital because he talks to his mother. He goes to the hospital because he doesn't want Corey to die in his house. He doesn't care about Corey. The only person he cares about is himself. He tells Brianna that Corey is lethargic, his legs are hurting, sleeping all day, throwing up, and he just didn't feel good and asked her to send the insurance card. But he does not say anything to anyone else about being wrong with Corey and the other people that he was communicating with. And at this point in time, ladies and gentlemen, this is at 3:30 in the afternoon. And yeah, all these things are happening. Because Corey is suffering in that house. He does not tell Corey's mother which hospital he is taking Corey to. Because the defendant knows that if anyone else speaks to these doctors, that all of this is going to be a problem for him. And instead of taking Corey and calling an ambulance and exercising any type of care for this child, he puts him in the back seat of his car. Corey is in critical condition when he arrives at that hospital. He's not being treated by 911. He's just in the back seat of the car. And that's the back seat of the car, right? With the towels. And that's what he did. Driving to the hospital. And you can see him here. Gets to the emergency room. Oh, it's going to take him out of the back seat. And you can see Corey's condition. You can see his legs. You can see in this particular video the condition of Corey, right? And how he has no strength left, and he's holding on to his father, and his legs are dangling. And as you continue on in this video, you can actually see the part of it where Corey's head goes back. And this is what Nurse Doyle is talking about in terms of the agonal breathing. Corey arrives at the hospital presenting with trauma at 3:48 p.m. Corey cannot exit the car or walk, doesn't call 911. Defendant does not make a scene or convey any type of urgency as he casually walks into the desk holding his then limp son, who is less than an hour and a half from his death. And that's what the nurses are talking about, right? Think about it. Any parent, any person, if your child was that sick, you'd be yelling, you'd be screaming, you would be in some type of panic. And that is what the nurses are describing at the hospital. Nurse Doyle tells us that he observes Corey, he is pale, he is lethargic, he is stuporous, he is nonverbal, and agonal breathing, which he describes as death breaths, right? He's taking his last breaths. The defendant provides a clinical description of what is happening to Corey. And again, this is what the nurses are talking about, right? Earlier in the day, around 9 o'clock, he says he's dropped off by his mother. Oh, then he was at Jersey Shore the night before. He had a workup and was discharged. Early that morning, he appeared loopy and drowsy. And there's nothing to note whatsoever to indicate that the defendant actually made any of these observations, right? And the point, ladies and gentlemen, is that he is not acting like a concerned or caring father in any regard. And you can see that in his demeanor, his calmness, right? With a limp child hanging off of you, of how he's acting. Defendant makes excuses and deflects in the emergency room before Corey dies. He's admitted at 3:53. Nurse Doyle is still present, but Corey is mainly cared for Nurse Carnevale. And when Corey is brought to the room, she describes the defendant as emotionless. She's not talking about the outside. She's talking about when he is inside room 6, when the defendant is talking about the case history, what symptoms, what's happening to Corey. And she is describing this as emotionless, and Doyle describes this as clinical. Because you know why? Parents, or anybody, if this was the condition as your child, you wouldn't be able to calmly walk in and say, oh, he's having symptoms. No. That is inconsistent with any type of behavior of a parent or anyone in regard to any person. Defendant now, at this point, right, this is the condition of Corey, he starts talking about Brianna, right? Because what is he doing? He's already here, going to the hospital with a purpose, with the purpose to deflect and to distract, right? And the defendant doesn't allow the nurse to even call Brianna. No, don't call his mother. Oh, she's a drug addict. What does that have to do with anything at this moment? The defendant says that Corey vomited. He complained of leg pain before he brought him to the ER. Defendant tells nobody at the hospital that Corey defecated his pants, right? That shouldn't be an important thing to talk about, but yet he can talk about Brianna, Corey's mother, in this calm state. He didn't tell anybody at the hospital that there was a loss of consciousness. That didn't apparently matter. In his calm state while this is happening to his son. He's basically providing unassuming symptoms, right? And criticism of Brianna at the time when the actual facts, the actual symptoms would have mattered most. That's not what this is about for him. Corey is pronounced at 5:03, and the defendant is not at his bedside, right? Pediatric CPR was administered, right? And we heard Nurse Carnival talk about it. One-handed pediatric CPR because he was 6 years old. Corey codes and he seizes, right? And what happens is, and this is in the testimony, right, he codes and seizes, and then they're able to get pulses back. Then they get him to the CT scan, right, because they get pulses back, right? So this is this whole thing with CPR. It's not a continuous act of CPR. They get pulses back, and they try to bring him to get the scan. And Corey codes again. If you see this video, right, where the defendant is now outside of the room, the defendant does not have a breakdown due to grief. He has a breakdown because now he knows that he is going to be on the hook for what happened. He is at the bedside at 4:51 for a matter of minutes, and then he chooses to leave, right? In this video that the defense showed you, if you actually watch the video, you can see at one point where there's like the nurse is pulling on him to come back because he just wants to get out of there. His only tears were for himself because what he did. Instead of staying with his son, he flees. Medical staff stayed in room 6 with Corey. The defendant did not. Brianna calls the defendant right before and after Corey dies. Doesn't answer. The defendant goes back to the waiting room, and what does he do? He calls his parents. At 5:10, David Gregor called the police and told the defendant that he was going to call the police. After hearing this, the defendant leaves the hospital. He goes out the nearest door, right? Not the door that he came into, because you could see him walking in the video. And he casually gets in his car and drives away at 5:20 without any hesitation, upright, phone in hand. Your son just passed away. And this is the most important part of this case, right? If your son had just passed away and you did not know why, right? Oh, this was an infection. This was sepsis. If you had no idea, the last thing you would ever do is leave, right? You would be at that hospital demanding answers. What happened to my son? You would be screaming and yelling. But you know what? The defendant didn't have to do that because you know why? He already had the answers because he knew what he did, right? If he thought Brianna had anything to do with it, he would have been calling and screaming at her, what did you do to my son? He does none of this because he already had the answers, right? Because that is not how any normal human being would act in those circumstances when a 6-year-old son just passes away and you don't know why. You would stay there as long as you possibly can. You would do anything to find answers. The defendant is gone before his parents arrive, and his parents have to clean up the mess. The defendant does not search for answers, and no one at the hospital talks about a GI bleed. And you can see him right there when he's leaving the hospital. Oh, man, my 6-year-old just died. So that's what a father does, ladies and gentlemen. He's able to drive. He's able to talk on the phone. The defendant fled because he knew what he did. The defendant was the last person with Corey. He knew that he was going to be investigated, and he knew what he did. So he gave himself distance and time. The defendant put hundreds of miles and multiple states between him and what he knowingly did to Corey. A Barnegat sergeant calls the defendant at 5:24. He rejects the phone call. At 5:25, there's a missed call. At 6:10, he states, can your phone be tracked in airplane mode? And can my car be tracked? This is what he's searching after his 6-year-old son dies. He did not want the police to find his car, his phone, or him. This is not because he is concerned about Corey. He's concerned about himself. The defendant then puts his phone in airplane mode from 6:31 p.m. on April 2nd, right after he's searching, can you be tracked, puts his phone in airplane mode, and doesn't even put it on again until the next day, April 3rd at 2:19 p.m. He then turns his phone back on. And when he turns the phone back on, where is he? He's in Arkansas, near the Texas border. That's how someone acts when their son dies and they don't know how it happens. The defendant's flight is highly corroborative of his guilt. And the judge is also going to talk about consciousness of guilt and give you a charge relating to this, right? He didn't just go to another place in New Jersey or a home of a relative or a friend to say, oh, I'm mourning and this is so terrible. But he travels a substantial distance and he does this quickly. He's already in that location by that time. How fast is he going? This is not an expression of grief. Okay, and then what continues to happen is a girl comes down and he meets her at the airport, right? And ultimately, there's testimony from the defendant's father that, hey, that summer, him and his girlfriend are going on the Appalachian Trail, taking a van trip to Maine. He is no longer encumbered by Corey, who is a stranger to him. The defendant only comes back because he is assured by his father. He does not turn around until after he spoke to his father for about 25 minutes. And his father tells him, you got to come back. He knows the status of the investigation, and he's not yet been charged. And what does he do? He stops outside of Nashville, of all places. Oh, my son just died. Let me go to Nashville, right? That's a grieving father. And then he picks up Laura, a girl in Tennessee, at the airport, where he's stopped by the members at the Alcoa Police Department. And his car and his phone at that point are taken. So grieving, I'm going to go meet this girl in Tennessee. Said the judge is going to speak to you in the charge about consciousness of guilt, right? And there's deleted and missing texts and about these web searches, right? The loss of consciousness, sleepy and nauseous. This search is from 3:08 on April 2nd. This is deleted after that time and before when his phone is taken while stopped by the Alcoa Police Department after picking up Laura on April 4th. Between the defendant's last communication with Brianna around 3:20 p.m. on April 2nd and when his phone is taken from being stopped with the Alcoa Police Department, the defendant deletes all of his text messages with Brianna. And we have the text messages because there's testimony that Brianna provided us with her phone. And this involved the testimony of Sergeant Coles. There are no individual text messages with either the defendant's mom or dad before April 3rd. The defendant manually deleted things from his phone that were the most damaging to him of what he thought was damaging to him. And arguments with Brianna, discussions, and regarding Corey's treatment or doctor's visits on April 1st. And what parent deletes this after his child passes away? Right? Again, you don't know what happens to Corey, but I'm going to delete my phone. Come on, ladies and gentlemen. Common sense. These deletions are intentional because there's texts from others within this time frame. There's texts with Amy and Laura, and the texts that are there are only the texts that say negative things about Corey's mom. When the defendant is in Arkansas and Tennessee, he searches the internet for alternate facts and explanations for what he did. The defendant knew what he did to Corey and where he hid him, right? So he's trying now to make this fit. Sergeant Coles testifies that these were his searches. What causes a rise in blood sugar and white blood cells? Could internal bleeding raise your blood sugar levels? How does gastrointestinal bleeding happen? Can a GI bleed be slow? There was a murder determined from an autopsy. How long to file charge? Okay? This is not rooted in grief. It shows you, again, phones right there are like an image into someone's mind. Why is he looking up GI bleeds and all of these things? Because he knew where he hit Corey. That's why he's looking them up. In terms of the investigation, the police speak to David Gregor. Mr. Gregor sees the treadmill video, and he tells us that he's actually the person who took care of Corey, right, and living in Monroe. And this corroborates the fact that the defendant didn't care or really know his son. There was also testimony from Sergeant Scuddy, right, that he had attended the autopsy and that they immediately started their investigation, right, and that's what they do, and that's why we know about the garbage, right, because Sergeant Scuddy didn't go on a wild goose chase and start tearing up this apartment for blood when there's internal injuries, because he goes to the autopsy and he knows that it's internal, and what does he do? He starts looking at the garbage, which is an insight to what was happening on that day. The other sergeant testified about the defendant's car and phone, which were recovered in Alcoa. Ladies and gentlemen, again, based upon the witnesses that have testified, based upon the evidence that was presented in this courtroom, there is no doubt, firmly convinced that the defendant is the only person who did this to his own son. Corey Travis Micciolo was 6 years old. He was in first grade. He loved the solar system. He was described as being silly and smart. He was murdered by his father, the person who was supposed to protect him and take care of him the most. There's no question what he did to Corey on April 2nd. His final act of child abuse. This case is about Corey. This case is about Corey and how he became the ultimate victim of the defendant's punishment and abuse. 6-year-olds just don't die, and neither did Corey. State thanks you for your time and consideration, myself and Assistant Prosecutor Schroem. Thank you.
Thank you. So obviously it's late. I think we all agree we'll charge a jury tomorrow.
Yes.
Any objection to that? So ladies and gentlemen, I ask you to come in at 9 tomorrow. Probably be better for parking, I would hope. There's another judge in jury selection, so that probably adds another couple hundred people to the parking garage, which is already limited. So coming in at 10 probably gave you some more difficulties than I anticipated. Again, we're going to recess, but you still need the jury instructions. You're the judges of the facts, but you have to apply the facts as you find them to the laws I give them to you. So you can't start to think about things yet, and the only time you're allowed to deliberate, of course, is when you're together in the jury room. So please don't discuss the case. Please don't look up any news articles. I'm going to do it for you. Again, just tell your immediate family and your employer, if you have to report in, that trial's continuing, you're coming back tomorrow, and please don't say anything else. Again, if anyone comes up to you, if anyone says anything to you, whether at home or outside, don't discuss it with that person, and don't tell your fellow jurors. Report it to me immediately tomorrow. I think juror number 13, you had said you have something tomorrow afternoon. Oh, it's Friday. Okay. So for now, we'll worry about that tomorrow afternoon then. All right. Thank you. I misunderstood. So anything else from counsel?
No, Judge, thank you.
All right. Thanks so much, ladies and gentlemen.
It's the yellow one.
Thanks. I'll see you tomorrow.
Yep.
Good, John.
All right, it's 5 p.m. The jury has left the jury room. Tomorrow morning, the court will open. It'll be an open public court, but once I reach the point of providing the final charge to the jury, our court rules require that the sheriff's officers then lock the doors. So you're welcome to come, any member of the public or anyone else, but once you're in here and I start the charge, you can't get out. So then you're stuck for the whole time. So not obligated to come, but if you're certainly welcome to come if you want to. But my point is that you can't decide after a half hour that you don't want to hear me reading the law and you want to get up and leave. So the idea is that there should be no distractions while the final charge is administered to the jurors. Anything from counsel at all?
No, Judge, thank you.
All right, thanks everyone. If you could try and start right on time to give the jury as much time as possible thereafter to consider the case tomorrow. See you tomorrow.